What is everybody? Welcome back into Truth and Transparency on this lovely Monday. Monday. Karen Read, House defendants slapping it. Again, this is my continuing coverage in the Karen Read case. Truth and Transparency, myself here, we've covered the two trials of Karen Read. Hung jury in the first one. She was acquitted of everything except for drinking and driving in the second one. And now she is filed against 3 different officers in their capacity as individuals. And then she filed against the town of Canton and then some House defendants. So, good afternoon. I have her amended complaint here. So I'll be going back and forth. But I hate to say this, but I know that I'm not a lawyer. Actually, I don't hate that I have to say that part of it. You know, fuck being a lawyer. Their moral compass is just not my cup of tea. But I'm going to point out some things. And these are things that I've been saying from the jump, that if you were to attack your case differently, I think you would be making way more compelling arguments. So let's just see. Karen Read files. Now we come back, and now the House defendants are going to file. And it says right off the rip, plaintiff Karen Read was given a full opportunity to cure her deficient pleading. She failed, and instead only made the case for dismissal stronger right out the gate. I'm like, okay, wow, that really grabs your attention. So the amended complaint, that is Karen Read's that she filed right here. And it'll be called AC. So moving forward, when you see AC, that's amended complaint. It doubles down on the same fatal theories, the same conspiratorial fictions, and the same baseless allegations. It bolsters accusations that are immune from liability based on hundreds of years of controlling precedent, and highlights that dismissal is not just appropriate, but it is unavoidable. Now, what this means is this. I'm going to give you guys it to layman's. I'm breaking all this stuff down in layman's terms. Layman's for our lay minds, right? Yoda yoda lay hee hoo. Well, basically, if you testify as a witness for the government, whether it's a state, commonwealth, you testify. You have protections that you cannot then be sought after in a civil case for your testimony. Okay? So that is where we're going to get into when they filed this. We're going to talk about absolute immunity, and we're going to talk about the Anti-SLAPP statute. Okay? That's why my live is titled House Defendants Slapping It. Okay? So, if you were to testify for the government in a case, whatever you say, even if it is absolutely wild, crazy, ridiculous lies, you're protected from a civil lawsuit. Wow, Lana, no way. Yeah. Let's see how that's possible. I was very interested in that, right? So the material facts, as alleged throughout the amended complaint and detailed in publicly available information that Ms. Read now incorporates by reference, cannot be reasonably disputed. Just after midnight on January 29th, 2022, after a night of heavy drinking, Ms. Read dropped off Boston police officer John O'Keefe outside of 34 Fairview Road in Canton, Massachusetts. So devastating to see that Karen Read went ahead and wrote that down. What has Lana always said? Karen Read was found guilty of drinking and driving. Okay. She was drinking that night. They all were. How does Karen Read know where she truly dropped off John? She didn't have it in her GPS. She had not in her phone, not in her car, nothing. John was supposedly handling that. Okay. But the evidence shows and proves that over there in Hog Heaven, Oakdale, is where John got out of the vehicle and started walking. Or you can believe the theory that it was the bumpiest road ever and he's just getting all of these steps and all these flights of stairs. It's the flattest road ever. Okay? So the reason my way of going about it would have been amazing is because the House defendants say that John O'Keefe never entered the home. Okay? Karen herself says that the victim, John O'Keefe, never entered the home. So how are you even going to say that they decided to concoct this plan, this phrase, tell me didn't go in the house? Karen says it herself. What I believe that Karen should have always maintained is that she has no idea where she dropped off John because she had never been to this location. She had no idea. That's the truth. How would she know where she dropped John off? She'd never been there before. But hey, they want to live and die by certain things, which is, they're right. Where he was later found dead, lying on the frozen ground in the midst of a blizzard. The following morning, still intoxicated, Miss Reed admitted to police that she drove Officer O'Keefe to 34 Fairview. Now, that's in an unrecorded statement. So you're going to be able to say that, hey, that's in an unrecorded statement. Miss Reed gave interviews, or one that was not recorded, just like some stuff happened with like the other people that are, were witnesses. But Miss Reed admitted to police that she drove Officer O'Keefe to 34 Fairview and that she never saw him enter the home. She also could not explain recently sustained damage to the back of her car. Miss Reed told witnesses at the scene, I hit him. Within 3 days, she was arrested. Miss Reed was then indicted by a grand jury and prosecuted twice. In 2024, the jury was unable to render a verdict based on the evidence presented. And so see how they're saying that? Based on the evidence presented. And in 2025, a jury acquitted her of murder, manslaughter, and leaving the scene of an accident, but convicted her of operating a vehicle while intoxicated. Here you go. There's the defendants. Okay. And they're going to call them the Commonwealth witnesses. They were questioned by police about the events of January 29th, and each testified on behalf of the Commonwealth during at least one of Miss Reed's criminal trials. For that and that alone, Miss Reed now seeks civil money damages from each of them. Well, I don't believe it's for that and that alone. Hi, Josie's on a vacation far away. We just got started. And Josie, we're going to be talking all about Kevin Albert. Don't you worry. We're going to give some credit where credit's due. Josie's been working hard. She deserves a lot of credit for the work that she's been doing, continuing to do for John O'Keefe. We're going to talk about that. So, remember what I just said a couple minutes ago. Was it yesterday? The day before yesterday? Maybe it wasn't even yesterday. I did like 3 hours of research before I did an 8-hour live on the lawsuit that Karen Reed filed, but more importantly, this filing by the Alberts, who they all have the same attorney. Because I wanted to know about this whole thing. Like, wait, you can just kind of, let's just say for argument's sake, that all these people lied. It doesn't matter. That's what I found out. Is that holy shit, it does not matter what they said. Like, so you know the law, right? Know your know how this all operates, know your precedent. So here is what they mean. So the amended complaint attempts to assert 5 counts against each Commonwealth witness. So number 1 is conspiracy to deprive Miss Reed of her Fourth Amendment rights. That's the 1983 conspiracy claim. 2 is the violation of the Massachusetts Civil Rights Act, which is MCRA. That's being abbreviated. 3 is malicious prosecution. And 4 intentional infliction of emotional distress, and 5 is civil conspiracy. Each count is premised on the same protected conduct: speaking to police and testifying at trial. So what they're claiming here is that Miss Reed had an opportunity to amend her complaint. Okay. She made it worse. And that basically each and every one of these counts, they're all protected because you're allowed, you cannot be civilly liable for anything that you said while talking to police for a judicial matter and testifying and shit like that. So, but your actions is different. And that's why I believe that it was imperative to say that you didn't know what house you dropped him off at, because I just don't believe that you did. How do you know where you dropped him off at if you're that fucked up? You said that the house looked like there was nothing going on there. The lights were off, all this shit. She never once said how all these cars were coming up and pulling up behind her or waiting, you know, that she saw Higgins's Jeep. Don't you think that she would know Higgins's Jeep? She went to his house. Come on, man. Let's like just use our brains here for a second. She was just hammered. They all were. They were all drinking. So, at least with respect to the Commonwealth witnesses, the amended complaint, so this is that they're just saying, at least with respect to the Commonwealth witnesses, they're not talking about Yuri Buchanan, they're not talking about Proctor, they're not talking about Tully, they're not talking about the town of Canton. This attorney strictly works for these 5 peeps. So, at least with respect to the Commonwealth witnesses, the amended complaint is a transparent act of revenge. Striped of its rhetoric and salacious factual characterizations, it is a work of conspiratorial fiction devoid of any good faith basis in fact and in law. Most importantly, the word that I'm looking at there is in law. Miss Reed asserts a variety of conclusory and speculative allegations that are entitled to no difference on these motions to dismiss. The claims are unprecedented, violate controlling state and federal law, are plainly barred by the absolute immunity privilege, and fail on several other grounds. Now, we did our homework over here and we said Karen Reed's team had to have known that the McAlberts and Higgins, that they would be coming with this anti-SLAPP shit, okay? If you were not prepared for that, then you're an idiot. These lawyers are not idiots. They're very well versed, okay? So the other stuff that I was wanting to pay attention to is, what are their claims? What's Karen Reed's claims that they're actions, not things that they did and said at a trial or said to police? What can you focus on that has nothing to do with testimony? Because that's what she needs to pounce on. Because anything that they said in court, you can't use against them. I learned, that's new for me learning this. I don't cover civil cases. The only civil case that I took an interest in was the Moore case, because we were treating it as a criminal case because there was no criminal case and it became relevant. So here we go. First, the amended complaint violates Massachusetts anti-SLAPP statute. Okay. Because Miss Reed seeks to hold each witness liable for their petitioning activity, which is namely testifying at her criminal trials and speaking to police on or around January 29th. Testifying at a criminal proceeding and talking to police before they independently initiate criminal proceedings are core protected petitioning activities safeguarded by the anti-SLAPP statute. That is that the only relevant conduct alleged against each Commonwealth witness in connection with those 5 counts. Moreover, Ms. Reed cannot meet her burden under this anti-SLAPP statute of showing that each Commonwealth witness's statements had no basis whatsoever in fact. Beyond the anti-SLAPP statute, Ms. Reed's amended complaint must be dismissed because the Commonwealth witnesses are entitled to absolute immunity against civil liability for their trial testimony, grand jury testimony, statements to police, and statements to a quote unquote a separate law enforcement agency. I was like, holy shit, is this accurate? Is this true? And sure as shit, the bedrock of these cases are known as, these are the gold standard, Blanchard versus Kearney Hospital, Bristol Asphalt Company. So I was like, Bixby. So I was like, wow, this is crazy. Right? So I was like, dude, I'm learning something here. So the United States Supreme Court and Massachusetts Supreme Court, Judicial Court, have both held that witnesses like the Commonwealth witnesses here are entitled to absolute immunity for exactly these types of allegations. Even under the most favorable reading of Ms. Reed's claims, the Supreme Court has expressly extended absolute immunity to protect witness statements that were made in any relation to the judicial process, including when witnesses are accused of having engaged in a conspiracy to present false statements. I said, holy shit. Since Ms. Reed's amended complaint against the Commonwealth witnesses concerns their involvement in the judicial process, i.e. statements to law enforcement, trial testimony, and alleged conspiracy between them regarding their testimony, the amended complaint fails and must be dismissed. Then I said, oh shit. Most claims against the Commonwealth witnesses should also be dismissed for the independent reason that the allegations underlining them are over 4 years old. I was like, holy shit, there's statute of limitations that they didn't realize. Almost all claims premised on events dating back to late January of 2022, when the Commonwealth witnesses spoke to the police and on Ms. Reed's February 1st, 2022 arrest. Yet Ms. Reed's 1983 conspiracy, MCRA, and the IIED, and the civil conspiracy claims, they all have a 3-year statute of limitations that began to run as soon as Ms. Reed became aware of the alleged injuries underlining them. And so I said immediately, okay, this is going to all come on discovery. Like, when did Karen Reed obtain? Because if the Commonwealth, they wait so long to give you discovery. So when did Karen Reed know what these statements were? But who cares what the statements are, right? Because they can't even use that against, because you have immunity from that, right? So I'm like, what the fuck? They don't have blanket immunity in that situation. Well, we're going to get into it, Matthew. We're going to talk about what they can wiggle around. But if they think that they're going to use statements, their witness testimony, I don't think they're going to be able to do that. They can use actions. They can use the acts. So we'll see, right? Also, Ms. Reed can come back and say they're perceiving this to be X, Y, and Z, and it's not, right? This is what arguing is all about. It's the spin you put on something. And according to Ms. Reed, these aren't witnesses. These should be suspects, right? So Ms. Reed's unfounded malicious prosecution theory and the allegations regarding trial testimony in 2024 and 2025 do not alter those claims. Indeed, in her own court filing from the fall of 2022, which are incorporated by reference in the amended complaint, Ms. Reed argued the same baseless conspiratorial theories that she regurgitates here. And so basically it was like, I think June 10th, 2022 is when she got all of like the police reports that had the witness statements in it. So finally, all claims against the Commonwealth witnesses failed to satisfy even the generous pleading standard under Rule 12b-6. Make no mistake, on its face, this lawsuit is nothing more than an act of retribution brought against those who did nothing more than speak to police and testify for the Commonwealth at Miss Reed's trial. So now they say that any result other than dismissal would set a dangerous precedent for aggrieved criminal defendants to use the civil courts to sue adverse witnesses and potentially discourage future witnesses from being willing to stand up and tell the truth in the face of an orchestrated scheme like the one Miss Reed has hatched to attack and defame them. Whew. Well. This is the factual background. Oh, DB here. What's up? Officer O'Keefe's death. I love that they're calling him Officer O'Keefe. Love it. We all know this, right? And so what they're taking here when they're saying AC and they're given the paragraph, they're taking that straight from Miss Reed's amended complaint. So what I have underlined here is Miss Reed drove herself and Officer O'Keefe to 34 Fairview. I hated seeing that. Miss Reed did not enter the residence and instead left Officer O'Keefe at 34 Fairview alone. The next morning, Officer O'Keefe was found unresponsive on the front lawn of 34 Fairview. Miss Reed first discovered Officer O'Keefe almost immediately after she returned to 34 Fairview with Miss McCabe and third-party Carrie Roberts, despite an ongoing blizzard and it being dark outside. The investigation and arrest. Soon after Miss Reed discovered Officer O'Keefe's body in the darkness of a blizzard, the Canton Police Department, CPD, arrived at 34 Fairview. Several police officers, ambulance personnel, and the fire department arrived to assist. As part of the investigative efforts, CPD Michael Lank interviewed Mr. Albert, Mr. McCabe, and Miss McCabe. Now, again, they're taking this from the words of Karen Reed. See how Nicole's not even listed there? I'm curious about that. I'm so curious about that. Because she was supposedly there and she was talked to. But they don't say her name. And that's the vehicle that I'm saying is missing. It's clear as day when you look at the pictures the next morning. The Edge is there and the Explorer is there, but not Nicole Alberts's Caddy SUV. Matthew says Google disagrees with this motion. Obviously, the attorney knows the law better than Google, but I don't really trust this guy either way. This is my take on it. I'll tell you right off the rip. Karen Reed should be suing the police. Okay? She should be suing the police. Because it's their job, right? It's their job on why this was so fucked up, right? And I would take a huge ass settlement and go live a life and help people if that's what you want to do. But litigating and doing this type of shit, do you know how long this is going to take? Do you know what this is going to be like? I wouldn't want that. I wouldn't want that life. This is what I cover for. Like, that's what I do for a living, right? Pay me my millions of dollars. Fuck you people, right? And get me the hell away from everything in this area. And I'm off to Cali. Peace out. But I don't think Karen Reed, just like Aiden Carney, they're the most, in my opinion, vindictive people. So that's just my take. That's what I see. Now, later that day, the Massachusetts State Police seized Miss Reed's cell phone and car following an interview that Miss Reed gave to the MSP. After the seizure, said not before, investigators discovered that Miss Reed's car had a damaged taillight. Forensic analysis of the car also uncovered pieces of broken glass on Miss Reed's bumper that were at least partially consistent with a cocktail glass that Officer O'Keefe had been holding when he exited Miss Reed's vehicle at 34 Fairview. Now, remember what they did. They put all of the blame with the amended complaint for the framing of Karen Reed on Trooper Proctor. I would have never done that. If I'm suing these 5 people, I told you guys, who called in this wellness check to go over to the house knowing that the kids weren't there, right? Who left the Sean Good left his dash cam on, told troopers to take his, or told police officers from Canton to take his vehicle to go over there to check, to do this wellness check. Meanwhile, the dash cam's running with Karen Reed's vehicle that was left in a driveway, accessible to anybody to get pieces of that taillight, right? And that's at the same time that the garage door becomes stuck and that the Ring camera had activity that was deleted. Who planted the shoe? Who had the shoe? Proctor didn't have the shoe originally. You know what I'm saying? Like, his hat. Can't blame Karen for wanting blood. Of course she wants blood. That's not what I'm saying at all. I'm saying your life is more important. Because all this shit in the end, how many go Google this. How many civil cases actually go to trial? Google that shit. How long it takes, appeals. So, right here. On June 9th, 2022, a grand jury returned an indictment against Miss Reed, and she was ultimately charged with second-degree murder. On June 10th is when Miss Reed gets this big discovery. Okay. So the Commonwealth statement of the case. Now this is the Commonwealth statement of the case. Following her indictment, the Commonwealth publicly filed on Miss Reed's criminal docket in the Norfolk Superior Court a statement of the case, the Commonwealth statement, signed by District Attorney Michael Morrissey, setting forth a preliminary narration of the allegations against Miss Reed that justified her indictment. According to the Commonwealth statement, the police spoke with Miss McCabe on January 29th, who informed them that she had encouraged Miss Reed and Officer John O'Keefe to accept Mr. Albert's invitation to attend the gathering at 34 Fairview, but that the two never entered the home. The next time Miss McCabe heard from Miss Reed was at 4:53 a.m. on January 29th, when Miss Reed called Miss McCabe in a distraught state looking for Officer O'Keefe. Miss Reed then drove to Miss McCabe's home, where the two, along with non-party Carrie Roberts, began searching for Officer O'Keefe. According to the Commonwealth statement, Miss McCabe informed law enforcement that during that drive, Miss Reed asked, "Could I have hit him, and did I hit him?" Miss McCabe also confirmed, I said when, date of this first claim, that she saw that Miss Reed's taillight was cracked and missing pieces. That is a no Canton police report. Very important. When does that first show up in a statement that Michael Proctor printed, right? So Again, this is me going through it, and these are my questions that are in blue. The Commonwealth statement additionally details other witness statements gathered by law enforcement following the discovery of Officer O'Keefe, including those given by Mr. and Mrs. Albert, Mr. McCabe, and all confirmed Miss Albert's initial report that Officer O'Keefe never entered 34 Fairview on January 29th. Moreover, the Commonwealth statement outlines accounts given by emergency personnel who responded to the scene, including one by Canton firefighter. We all know this. Again, when was that first reported date? Now, Miss Reed also gave a brief statement to police on January 29th. Specifically, Miss Reed informed law enforcement that while she was invited to 34 Fairview the night prior, she did not enter the home, and that after dropping Officer O'Keefe off, she did not see him enter the home. Miss Reed stated that she did not see the victim enter the residence, emphasis added. Miss Reed also stated that she noticed that her taillight had been damaged the night before, but did not recall how the damage had occurred. Again, this is not recorded by law enforcement. The person who wrote the report was terminated. Reed's criminal trials. After 2 months of a testimony, the jury was unable to reach an unanimous verdict in trial 1, right? Approximately 1 year later, Miss Reed was tried again. We know what happened. The instant action. Almost 4 years after Officer O'Keefe's death, on November 17, 2025, Miss Reed filed this complaint and then amended the complaint on March 13, 2026. The amended complaint asserts 5 causes. We've gone over this. We've listed them. Okay. Based on information that the Commonwealth witnesses provided police, and because of their trial testimony for each count, Miss Reed seeks damages for loss of employment, private health insurance, and reputational harm caused by her arrest, indictment, and prosecutions. She's going to win all of that against the police. There's not a doubt in my mind that she should not win, right? She should fucking rake them. Literally rake them. This is the argument now for and on behalf of the House defendants, the Commonwealth witnesses. Their argument is that the case should be dismissed against the Commonwealth witnesses pursuant to Mass General Law 231, the Anti-SLAPP statute. Well, the Massachusetts Anti-SLAPP statute was enacted to counteract SLAPP suits, defined broadly as lawsuits brought primarily to chill the valid exercise of the constitutional rights of freedom of speech. Well, that is not why Karen Reed brought this. They're going to have no problem, in my opinion, showing that this is not that. We're not chilling anybody's, constitutional right of freedom of speech. So, but they put that in there. I don't think they have a prayer on that. They've done interviews, right? So, but the anti-SLAPP statute applies to state laws claims filed in federal court. So the Massachusetts Supreme Judicial Court recently adopted a simplified anti-SLAPP framework. First, the movement must show that the challenged count has no substantial basis in conduct other than or in addition to the special motion proponents' alleged petitioning activity. So again, it cannot be about what you're testifying to. So to determine if statements are petitioning, courts consider them in the overall context in which they were made. So this is where they're getting and citing all these bedrock gold standard cases. I'm going to go. So further in assessing whether there is any non-petitioning conduct, a judge considers only the allegations that are relevant to the discrete causes of action brought. So here we go. If the moving party meets that burden, the second stage shifts then to the opposing party. Ms. Reed must show by a preponderance of the evidence that each Commonwealth witness's petitioning activities were devoid of any reasonable factual support or any arguable basis in law and caused actual injury to her. Now, how are you going to be able, this is the best argument, is that absolutely, because they know the truth, right? If they know the truth, then like, what's up? Like, then they were lying, right? And I'm like, okay. Like, wouldn't that be your argument? Like, so you, but it's on misread, right? Because it shifts the, here you go. So I was like, okay, let's see. So each state law claim against each Commonwealth witness is based on a petitioning activity. So for each asserted state law claim against each Commonwealth witness, Miss Reed complains that she was injured because of her arrest, her indictment, and the prosecution of her. The only alleged conduct by each Commonwealth witness relevant to this alleged injury is the fact that each gave information to police and testified at Miss Reed's criminal trials. Now, when I went then through back to look at the amended complaint, right, to see, is that true? And no, it's not all of it, because you have to look at the activity, right? And if they would have said what I said to show, which was Jennifer Drake went up a flight of stairs with her watch, but the phone never went up. So to show that it wasn't Jennifer actually using her own phone to do this alleged Google search and it was somebody else, wouldn't that look way better? Because that's an activity that has nothing to do with testifying or anything like that. This is conspiring acts. Matt McCabe knowing and doing something, right? And can you do the preponderance of the evidence to show a court, aka a jury, that, hey, Karen Reed went up, or Jennifer McCabe went upstairs. Here's her watch data. She goes upstairs. The phone doesn't. The phone stays on the first level and it never goes upstairs. Instead of talking about her being wildly active, like, fuck that. That was so bad, in my opinion. The argument is that the watch goes upstairs and the phone doesn't. And that Matt McCabe used his wife's phone, right, to be doing stuff on without Jen's knowledge, because that phone was still downstairs. Because in order for Jen to have used that phone, it would have had to go upstairs, right? Don't you think that's a better argument? Now, why would Matt McCabe use Jen's phone? Because Matt McCabe thought that his phone could potentially be sought after. And then you should wonder why that would be. So, but here we go. Let's see how they do it. My argument wouldn't have been different. That's all. But so Miss Reed's speculative and defamatory suggestion that the Commonwealth witnesses are responsible for Officer O'Keefe's death, a claim that Miss Reed lacks any good faith basis or evidence to assert, provides no basis for the state causes of action against them. Indeed, these salacious and baseless accusations are designed to further Miss Reed's scheme, which is to impugn the reputation of the Commonwealth witnesses, as Miss Reed does not and cannot assert a wrongful death claim or related tort against them. Miss Reed's attempt to hold private citizens civilly liable for speaking to police and for testifying at her trial pursuant to duly issued subpoenas is without precedent in Massachusetts. The effort to financially punish those who spoke to police and testified for the Commonwealth violates the core policy of the Anti-SLAPP statute to prevent meritless suits, in quotes, to deter common citizens from exercising their political or legal rights or to punish them for doing so. Now, Nicole Albert. It goes through each of them. Now, one can only ask themselves, hello, Lana is available to consult with. When I saw this, I about hit the floor. I was pissed. I'm pissed in the arguments that were made and the arguments that were not made. Where is Nicole Alberts' fucking vehicle, you guys? It's not in the garage because they don't park vehicles in the garage, and that was testified to. Where is her black caddy? It's not in the driveway. Good question, Lana. Where is it? Well, that's really important. That's an action. Miss McCabe called Nicole, right? An hour before the arrival, right? Whose car isn't there? And then Jen calls back to back at 6:07 and 6:08 her sister's phone. Why? Well, because she saw that her sister's vehicle wasn't there. And yet, here's Karen Reed's team. Miss Albert lived at 34 Fairview at the time of Officer John O'Keefe's death. There is no allegation that Miss Albert reached out to the police, initiated any criminal complaints against Miss Reed, or even mentioned Miss Reed to the police. Well, guess what? Meredith O'Neill needs to take one out of the book right here. There is evidence that Aiden Carney reached out to the police. Okay. In a ton of cases, Aiden Carney reached out to the police against people for the purpose of malicious prosecution. I cannot believe people aren't like going at that man left and right. Okay. When I saw that, I said, oh shit, Aiden. Fuck, man. So go ahead and put that in your back pocket. Next. Instead, Miss Albert is a fact witness whom the police interviewed on February 3rd, 2022. And I'm over here like, dude, everyone's over here not talking about that Miss Albert didn't talk while she was inside that home. She testified that when she came downstairs, like, what do you mean there was cops in her home? Everybody has totally gotten away from Nicole Albert being even like there, on January 29th. Very strange, but instead, Miss Albert is a fact witness whom the police interviewed on February 3rd. Miss Albert also testified at Miss Reed's first criminal trial. Beyond the unremarkable factual allegations that Miss Albert spoke to her husband and friends about Officer O'Keefe's death, the amended complaint is devoid of any other factual allegations against her. And I'm thinking, yeah. Well, group text messages, right? How about, since they did this anti-SLAPP thing, I think it stays the discovery process right now. They don't have her phone log or her text logs unless the Fed subpoenaed it and then the defense got it. I don't know that for sure. Location data, but I said, I put these over here on the side because the one thing that I knew I was going to be talking about, which is Nicole's vehicle isn't there. So where is Nicole? How do you blow that opportunity? How do you seriously blow that opportunity? Now, there's going to be a verified complaint that's Karen Reed's next move here is a verified complaint. If someone doesn't fucking call Karen Reed and tell her how she could beef up Nicole Albert's shit, well, I don't know. I'm not calling. But it's laughable if you cannot look at the crime scene photos and not see that her fucking car's missing. So whatever. And it would help with the fact that the tire tracks were so easily able to be covered back up within however much time, because the only tire tracks you could see with the Canton police taking a photo is Jennifer McCabe's husband when he pulls in, which would actually help Karen Reed. And when they're talking about that, there's no foot tracks or anything on the lawn and shit like that. Those are getting covered so fast because of the rapid pace of the downfall of snow. Okay. And this would be a huge way of showing that. They're all hung up on this Ford Edge, and it's just unfortunate. It's unfortunate that you listen to Turtle Boy. It's unfortunate that you got, and then they're listening to someone like Scanlon, who then is nowhere to be found. So the next thing is malicious prosecution here. First, for malicious prosecution of Nicole Albert, Miss Reed must establish 1, the commencement or continuation of a criminal proceeding against Miss Reed at the behest of Miss Albert. 2, the termination of proceeding in favor of Miss Reed. 3, an absence of probable cause for the charges. And 4, actual malice. Because a malicious prosecution claim is based on the initiation of a civil or criminal legal proceeding, it is commonly subject to an anti-SLAPP motion. Miss Reed's malicious prosecution claim against Miss Albert and the other Commonwealth witnesses is no different. She alleges that Miss Albert falsely told police on February 3rd that Officer O'Keefe did not enter her home on January 29th and testified at Miss Reed's first trial, and that such statements and testimony caused Miss Reed damages. Providing information to the police and testifying at a trial is protected petitioning activity. So what's up with that? Is it protected? Can that be used against them? And if it can't, then all you have is the activity that doesn't have to go with the testimony. Oh, hell yeah, Turtle Boy has caused so much serious damage to Karen Reed. Him not shutting up has caused Karen Reed so much damage because he cannot shut the fuck up. But hey. Miss Reed alleges no other conduct by Miss Albert, that is relevant to the commencement of the criminal action against Miss Reed. And it's like, well, God, if you had mentioned her vehicle not being there. That is, remember, this is not beyond a reasonable doubt. This is the preponderance of the evidence. That would show, a preponderance of the evidence would show that Miss Albert isn't potentially there, right? And we want to talk about conspiring. Well, that would link. Somebody's not there, you guys, because Nicole Albert's vehicle is not there. Whether it's Nicole that took that vehicle out of there, whether it's Brian, somebody took Nicole's black Caddy SUV. Josie says it's Caitlin with Chloe. It could be someone with Chloe. It could have been going over to Lank's house, giving him something. But how you do not mention this, if you're Karen Reed, is absolutely beyond me. Like, the pictures prove that the car is missing. What the fuck? All these people that talk about the Karen Reed case and nobody's bringing that up. Why? Because Lana said it. But if Melanie Little said it, y'all would be literally on all fours rubbing and scratching and sniffing. Wild. Also, what needs to go in there is about the Ring cameras. At the beginning of this whole thing, it was said that I find it hard to believe that the Alberts wouldn't have had some type of security system at their home. That's an act. If they got rid of it and destroyed a Ring camera, right? Those are actions. That's conspiracy. Okay. So, since Miss Reed alleges no other conduct, and all she does is say that Miss Albert was in a group text message. Okay. Well, Miss Reed alleges that one or more of the Commonwealth witnesses relocated O'Keefe's body and deposited it in the front of the Alberts' house. Now, this is where I just wanted to go into a hole, because I'm like, this is exactly why you'd want to say that Karen didn't drop him off at 34 Fairview. Because then how did John's body get to 34 Fairview? Wouldn't that be a really, really strong argument? Karen Reed has never testified under oath. It does not matter what Karen Reed has told any it's all about trial strategy, okay? Karen Reed could say whatever she wanted to reporters. And for trial strategy purposes with her criminal defense that she knew she was never testifying at, it was strategic for her to say certain things so that the Commonwealth would stay in a lane. Okay? Because of how the defense, they said, in my opinion, listen, we're going to prove that the murder weapon isn't the murder weapon. That was their only goal. And that we're going to use their own witnesses to show that there was no body on the lawn. Okay? So the murder weapon isn't the murder weapon. And that's why they kind of went away from the data as far as John's phone. Because that in and of itself is reasonable doubt. We cannot just go off of phones and that the data is always accurate. Especially when you want to use Jennifer Drake, I almost said, Jennifer McCabe's phone and her steps and compare everything just to say how are you going up a flight of stairs with your phone in your hand to go tell your sister at 6:30 in the morning, right? Hey, there's cops here. John's outside and he's being taken away in an ambulance. We need you to come down here. Well, or her watch goes up a flight of stairs, but her phone doesn't. Because she didn't have her phone. It was with Suge Tits Carrie. But anyways, back to this motion. So indeed, Miss Reed included this allegation in what appears to be a misguided attempt to bypass the statute. So what the Commonwealth witnesses are saying is that this whole alleged of Miss Reed's claiming in her amended complaint that one or more of the Commonwealth witnesses relocated John O'Keefe's body and put him in the front lawn of the Alberts house. Okay. That's the act. Well, how much better of that act would it look if Karen's over here saying, yeah, I never saw him go in 34 Fairview. I never saw him go in that house because I never dropped him off there. That's not where I dropped him off at. We clearly had gotten lost. Where I had dropped him off was somewhere over here. I'd never been at 34 Fairview. Where I had dropped him off is where I thought 34 Fairview was. That would make all the sense in the world to me. And then that's where she left from. That's why it would make sense to me as well, is to say that we all have to have our story straight, that not only did they not come in here, right, but that she came to this house. But instead, in the amended complaint, they say Karen Reed got to 34 Fairview at 12:20. There is no data that supports that. Even if Karen Reed got and went to 34 Fairview, they didn't get there at 12:20. We'll get into it. So, as an initial matter, Miss Reed does not allege that Miss Albert relocated Officer John O'Keefe's body. Rather, she simply speculates that one or more of the Commonwealth witnesses relocated the body. Well, DNA was not tested from O'Keefe's shoes, clothes against the House defendants, just so we're clear. And so, is that going to have a chance of that happening? They have DNA. They never ran anything against anybody. They have mixtures. So what can happen here? And then since people were out with him, right? Would it even hold any weight? Well, we have the entire waterfall video from that night. And I don't think that John O'Keefe and Nicole, right, ever come in contact. So can we get anything off of this DNA? And when would that be able to happen? Like, and then let's say that there was DNA and that these people's mixtures came out to like be the people that he was hanging out with. Well, wouldn't the argument be that of course he'd have their DNA could be present on his clothing, his shoes. They were all out together. What do you think about that argument? I would say, yeah, not Colin though. Right? So I'm waiting for that to see what type of movement there could be with like DNA, and then if there was, like, what does it mean as like from like a juror standpoint? Like what would be the weight of that? For the court to draw inferences in favor of a plaintiff, that's Karen Reed here, the complainant must allege facts linking each defendant to the grounds on which the particular defendant is potentially liable. So complaints are dismissed where they do not identify who, if any, of the individual defendants was responsible for the purported misconduct. So is this where it's going to be like, we need to test? I mean, who are you going to say moved his body? And I'm over here like, you could have avoided all of this if you say you didn't drop him off at 34 Fairview. Because the data reflects that y'all were over there in hog heaven on Oakdale and Cedar Crest, making 2 loops over there where Lank and these other cops live, where other Blizzard parties were happening. And wouldn't that kind of just in and of itself, your argument is that this is where this is where I left him. And so clearly for John to have gotten anywhere over there and be on that lawn, how did he get there? Well, I think that's where Higgins comes into play. Because Higgins's Jeep was missing, right? Where was Higgins's Jeep? It was missing because, you come in here. Where's here? Was it at 34 Fairview, or did they talk when they were all there that, hey, we're going to stop over here first and then go there? I'm just saying, you got to this is your trial strategy. You're not, Karen Reed never testified. Never. And a case is fluid. When you learn more things, it is what it is. Okay? So How Karen Reed cannot say that she's learned more things and needs to consider more things. You have the data that proves that John got out of a vehicle and was walking around in registered steps and stairs. Why wouldn't you go with the fact that he got out of your vehicle at that 12:20 time frame? Well, guess where that's at? That's not at 34 Fairview. And you thought that the house looked like it was all dark and shit. And so that's when he walks up to try to go figure out if this is the house and if we're invited. So why wouldn't Karen Reed say that? Why are you marrying the fact that you took him to 34 Fairview when you do not have to? When the data actually supports that you didn't and that you were definitely at a different location first. You know, I don't know how come that's not like, what the fuck? I'd be going off if I was in Karen Reed's shoes talking about to my lawyers about this. And I would say, well, I want to know the arguments from every which way because I don't understand why this was this makes way more sense. Because I didn't see people out and about coming and going into a house. I didn't see any of that shit. Like, maybe I wasn't at 34 Fairview when I dropped him off. That makes way more sense that I dropped him off at a location that wasn't 34 Fairview. And why Michael Proctor was over there in the area of Dedham and Hog Heaven, Oakdale, and Cedar Crest and all that shit, looking for Ring camera footage to bury it. That's what I think. They weren't going and getting camera footage to prove anything. They were getting stuff to destroy it. So we'll go and move on to right here. Further, this allegation is not pertinent to the malicious prosecution claim. The question is whether Miss Reed alleges that Miss Albert engaged in any conduct germane to her malicious prosecution claim apart from Miss Albert's statements to the police, which can provide a substantial basis for her claim. The answer is no. An allegation that one or more of the Commonwealth witnesses relocated Officer O'Keefe's body is not relevant to whether Miss Albert initiated criminal proceedings against Miss Reed. And remember, they're getting this because their witness is Lucky, and they're saying that Lucky was like, I made a pass by, and the first time there was nobody on the lawn and there was no vehicle. And then when I tried to go back down and around that way the second and third time, I couldn't go, remember? Or when I went, there was a vehicle, and they're saying that it was a Ford Edge, and it's like, you guys are idiots. It wasn't the Ford Edge. If anything, it was the Caddy that's not there in the morning because it's gone. But nobody actually paid attention to the fucking evidence. And instead, they listened to a blogger. You would never ask someone like Lucky a leading question to say, did you see a Ford Edge? You have to ask a question for them to describe the vehicle that they saw. Again, Karen Reed was found guilty of drinking and driving. You would use that also in your favor with this case. So, an allegation that one or more of the co-stars said that the conduct itself does not relate to any cause of action. Miss Albert could only possibly have achieved that by speaking to the police and testifying at trial. At best, that allegation is intended to show that the statements made by Miss Albert to the police were false and intended to cover up her own culpability. However, the motive behind the petitioning activity is irrelevant at this initial stage. Woo! And I was like, wait, what? Miss Reed's suggestion that the Commonwealth witnesses are responsible for Officer O'Keefe's death is irresponsible, knowingly false, and defamatory. To deflect her own responsibilities, Miss Reed has conspired with others to engage in a scheme to defame and injure the Commonwealth witnesses. Most importantly, Miss Reed has not pled a cause of action against any of the Commonwealth witnesses relating to Officer O'Keefe's death, such as a wrongful death action. Thus, Ms. Reed's allegations are irrelevant to the claims that she has brought and should be disregarded in the anti-SLAPP petitioning activity analysis. So basically, the argument here by the Commonwealth witnesses and their attorney is that they're sliding this little piece in to try to get around the anti-SLAPP, that one or more of these people clearly moved his body to over and hide it over here by the flagpole, blah, blah, blah. Well, I have to say that whoever this attorney is did a really good job at pointing out some stuff that we're going to get into here. Because you guys know I'm like a timeline whore. And the timeline that they're able to put in here to talk about the fact that, well, the one or multiple people that could have moved his body, they start eliminating people based on the amended complaint. Jen McCabe's home and at her house, they say at 2:12. They say the body wasn't moved until after 3:30 because they're going off of what Lucky said. And so then that eliminates, they're saying, Jen McCabe and Matt McCabe right off the rip because they were home and wildly active, okay, in their house, all right? Then they are able to eliminate, they think, Higgins because he left at 1:30 and is at the Canton Police Department. And I'm over here like, well, what the fuck? That doesn't mean he couldn't have gone back, you know? So I don't, that's shaky to me. But we're going to keep reading here. So here, Miss Reed alleges that Miss Albert interfered with Miss Reed's Fourth Amendment rights. Again, the only specifically alleged conduct against Miss Albert relevant to this account, conduct that could amount to threats, intimidation, or coercion, is that Miss Albert falsely told the police that Officer O'Keefe did not enter 34 Fairview and testified at the criminal trial. This conduct is plainly petitioning activity and is protected by the Anti-SLAPP statute. Now, the intentional infliction of emotional distress. Next, Miss Reed complains that Miss Albert is liable for IIED. And you have to show, Miss Reed alleges that one, the defendant intended to inflict emotional distress or knew or reasonably should have known that emotional distress was likely to result from such conduct. Two, the conduct was extreme and outrageous. Three, the conduct approximately caused plaintiff's emotional distress. And four, that the distress was so severe that no reasonable person could be expected to endure it. Well, Miss Reed again includes the same allegations as contained in her MCRA claim, namely that Miss Albert falsely represented to the police that Officer John O'Keefe never entered her home and provided false testimony at Reed's criminal trial. Other speculative or group pled allegations simply are not germane to the IIED claim. And they kind of leave it there. The final count against Miss Albert is for civil conspiracy. To state such a claim, Miss Reed must demonstrate that a combination of persons acted pursuant to an agreement. To injure the plaintiff. Again, Miss Reed regurgitates the same specific allegations against Miss Albert, namely that she lied to the police and then she lied at her trial testimony. Miss Reed also claims that Miss Albert texted and communicated with her husband, the McCabe's, and Mr. Higgins regarding what they each told the police about what happened to Officer O'Keefe. However, characterizing this Miss Albert's petitioning activity as a conspiracy because she allegedly discussed her petitioning activity with others does not avoid application of the Anti-SLAPP statute. And I was like, interesting. But things like planting evidence, manipulating evidence, destroying evidence, right? They don't ever claim that she got in her vehicle and left Um, you can say things like, upon information and belief, one or more of the. I mean, who drove her vehicle off that property? Nobody saw Chloe in the morning. Jen McCabe testified that she didn't remember seeing Chloe in the bedroom. So, as with the other counts, Miss Reed includes no specific factual allegations against Miss Albert outside of her petitioning activity that would support a conspiracy. And I just think that, God, how do you miss this opportunity to talk about her fucking vehicle being gone? Blows my mind. And then I bring up, well, what about the security system at 34 Fairview, or Ring, or a Nest system? If you subpoena in the future, if you subpoena and you can actually show that they actually had a system at that time, that'd be another thing. So I thought there was, upon information and belief, that they had one of those at the time of this happening, and then they got rid of it immediately and acted like they didn't have one. Or was that all just a bunch of lies that Aiden Carney was peddling? Because he didn't know the case and needed Karen Reed to put her tit in his fucking mouth to milk himself to be able to write a story. Aiden telling the world that he made Karen Reed. Karen Reed made you her bitch. You fucking idiot. Little errand boy. Now, next up is Matthew McCabe. Mr. McCabe lives in Canton. Was questioned by police on January 29th about the death of Officer O'Keefe and testified at Miss Reed's first criminal trial. Like Miss Albert, Miss Reed includes very few specific factual allegations against Mr. McCabe and identifies him only a handful of times, which is true. And I'm over here like, you have this opportunity to, like, literally, because you have more information, 1000%, you can separate the watch and the phone and show that Jen went upstairs with her watch on and the phone stayed down the first level. And it was when she was walking around with her watch upstairs. And then she's getting into her bed or whatever. That phone never makes a flight of stairs until 5:30 in the morning. So I don't know why you want to continue with the house law and a die Google search being Jennifer McCabe's, when this would show a conspiracy. This would show Matt McCabe using his wife's phone to do what you're alleging. Don't you think that intensifies everything for it? Makes it better. It's an activity that's not your testimony. They never thought that Jen's phone would ever be taken, right? But Matt McCabe, for some reason, thought that his phone could be potentially taken. That's what it would tell me. And here, if I use hers, right? Just saying, if you're going to die on this hill, that you're still going to go with the fact that this Google search happened at 2:27, which I believe that it did not, based on the artifacts and how it was all presented. It was a glitch in the system, and Salbright needs to look at who testified to that in any period of time around when that glitch was happening, and those people need to automatically be given a new trial. Period. That's what should be happening in the world right now. Because you bet your bottom dollar that people were fucking found guilty on that glitch. So here, The few references to Mr. McCabe are allegations almost identical to those against Miss Albert. Namely, Mr. McCabe was at 34 Fairview on January 29th. On that day, he told the police that Officer O'Keefe did not enter the home. 3, subsequently, Mr. McCabe was included on text messages with his wife and the Alberts regarding statements to the police. And 4, that Mr. McCabe testified at Miss Reed's criminal trial. I said Matt used Jen's phone and hid his knowledge and conduct. The watch and the iPhone data differences. I would be going that route, which is showing not testimony, okay, but that's actual acts. Also, if Jen's upstairs and the phone's still downstairs, all of the activity on the phone beginning at 4:53, Jen would have had to come downstairs to get that phone, because she couldn't have used her phone, right? If she's upstairs and her phone's downstairs. And the only time that could have happened is at that 3:51 when she basically got up to use the bathroom. And she realized, in my opinion, that Matt wasn't in the bed yet, right? And when you ever go down a flight of stairs, it doesn't register, but you're going to get those steps. And it's like she went down and then she like went to the couch and they were down there on the couch. And dozed off for a little bit. Or maybe they were just talking on the couch, whatever. But what you're able to then show is that at 5:28, I think it is, 5:30, the watch and the phone go up a flight of stairs. Okay? Together at the same time. That's the first time that the phone ever goes up a flight of stairs, is at 5:28. How you're not using this to your advantage, if you're Karen Reed, is fucking mind-blowing to me. Absolutely mind-blowing. This is the conspiracy that you're talking about, that you think is happening, and that there's knowledge that somebody is out there in the cold, right? And this is at the same time that these butt dials are happening at 2:22 with Higgins and Mr. Albert, right? Well, now, don't you think that maybe you'd want to throw in the fact that Matt McCabe used his wife's phone to try to mask his knowledge and involvement? Because for whatever reason, Matt thought that his phone was being taken. And for whatever reason, he didn't think that his wife's phone would ever be taken. Think of that. That is very, very interesting to me. Very, very interesting to me. And one should ask somebody why the phone didn't go up the stairs with Jen when she first came home. Because Matt had it. And he had it for a decent amount of time. Because that phone was in the car charging. I want someone to look at all, like, they can do a ton of shit. I would love to get the raw data and send it to somebody that I know. Okay. So now we move on to Jennifer. The amended complaint reflects Miss Reed's extraordinary animus and desire for revenge against Miss McCabe. That sentence wouldn't even be able to be said if you would be saying things about the device in Matt McCabe's. And that's why he didn't go out hunting with you guys. Matt had to stay back. Hey, take her back to the house. Leave that vehicle there. Okay. You want to talk about conspiracy? Miss Reed alleges that Miss McCabe lied to the police, lied to the FBI, and provided false testimony at Miss Reed's criminal trials. Like Miss Albert and Mr. McCabe, Miss McCabe's statements to law enforcement and trial testimony are core petitioning activities, rendering the state law claims against Miss McCabe barred under Massachusetts anti-SLAPP. Miss Reed's assertion that Miss McCabe's statements to police and her trial testimony were false and motivated to cover up Miss McCabe's own alleged involvement in Officer O'Keefe's death does not save these claims. When assessing whether alleged conduct is petitioning activity, the veracity or motivation of the alleged activity is not relevant. The amended complaint includes several additional allegations against Miss McCabe concerning her conduct on and after January 29th. But stripped of the sensational characterizations, which are entitled to no difference, Miss Reed merely alleges mundane conduct by Miss McCabe that is not relevant to any of the counts asserted. For example, Miss Reed alleges that Miss McCabe was wildly active, and I had a laugh because I said, this is exactly what I said. I said, this is the stupidest thing that you could have fucking wrote. Wildly active during the early morning hours of January 29th. Putting aside the characterization, the factual allegations reflect ordinary conduct. Miss Reed alleges Miss McCabe, 1, returned to her home at 2:12, 2, spent 13 minutes walking around her house, 3, stopped moving and opened her iPhone for approximately 6.5 minutes, and 4, then closed her phone and moved for 1 minute before settling back down. This is not wild activity, but rather is indicative of the actions of someone getting ready for bed. See how stupid they are? That phone is not on floor 2, you fucking idiots. But yet, Karen Reed has not presented that argument. And so it looks absolutely ridiculous when you lay it out like this. These allegations do not impact the anti-SLAPP petitioning activity analysis because they are not relevant to Miss Reed's counts. The phone never goes upstairs like the watch does. It's very simple. Miss Reed also alleges that at 2:27 a.m., Miss McCabe performed a Google search on her phone. Well, guess what? That Google search was on the first level. It never went upstairs. So, okay. And then the watch never goes on a second flight upstairs. So it couldn't be that Miss McCabe ever came downstairs to go back upstairs. You fucking idiots. Miss Reed, house long to die in the cold. This allegation has no good faith basis in fact or law. Look at this. At the second criminal trial, it was unrebutted that the Google search at issue, which notably was not even completed, occurred at 6:24 a.m. Indeed, the evidence at trial revealed that any contention that the Google search occurred at 2:27 a.m. was based on a fundamentally erroneous reading of the data. Remember, this was uncontested. And so I know the reason it was uncontested at the trial because that was something that they were leaving at the wayside. They were focusing on the two other things I talked about earlier. However, it should be who is conducting the activity on the phone, because it wasn't Jennifer. Did Lana read Yuri's response? No, not yet. Send it to me. Again, you're going to get... I'm covering this like... It's just facts, like factually. Like, Miss Reed can only avoid anti-SLAPP dismissal if this alleged conduct relates to the elements of the claims brought against Miss McCabe. So the answer is clearly that it does not. For example, a Google search conducted at 2:27 a.m. is not relevant to Miss Reed's malicious prosecution claim against Miss McCabe because that wasn't used to prosecute her, to prosecute Reed. You get it? Like, when you read that sentence, it is like, that's like a gut punch to all the fans of the defense. That's awful to see that, because it's true. That is this. It's not like Karen Reed was prosecuted because of that fucking Google search. And then even they found out about the Google search and Karen Reed was still prosecuted. Like, what? They have an argument for this Google search. This Google search was argued by an expert that said that there is a glitch in the system. And this is how it was. And this is why it read like that, which needed to be changed. So, again, for example, a Google search conducted at 2:27 a.m. is not relevant to Miss Reed's malicious prosecution claim against Miss McCabe, as it has nothing to do with initiating a criminal proceeding against Miss Reed. It's like, oh shit, that's right. This false allegation is only included to imply that Miss McCabe had some responsibility for Officer O'Keefe's death. But Miss Reed brings no such claim, nor could she, related to the death of Officer O'Keefe. Now, me and Bella were going back and forth on this, because I was like, are they basically saying that Karen Reed isn't claiming this is not a wrongful death suit, you know? And when they're saying that she's not bringing that claim against them, nor could she, are they insinuating that she could never bring that against anybody anyways, because she's not in a position to ever claim that? Because then I said, well, wouldn't Karen Reed have a companionship claim with the wrongful death and what it caused her, the wrongful death of John O'Keefe? Because that's exactly what they did in Idaho, and why Jennifer Drake was awarded, and her kids were awarded a bunch of fucking money, because they lost their dad and her husband, and right? So I was just curious about that. I don't know. Again, I don't claim to be a lawyer, but I can definitely sort out the facts of cases, put them in pretty disgusting timelines, and give you really good, give you the meat and potatoes that you would need as a lawyer to argue your position and win your argument. Because without the info, you're not winning shit. You're not able to win arguments. So, knowledge is power. Further, Miss Reed alleges again, without any good faith basis in fact or law, that Officer O'Keefe was not located on the lawn at 34 Fairview Road until after 3:30. As such, Miss Reed's allegations exclude Miss McCabe and her husband from any role in the alleged relocation of Officer O'Keefe's body, basically. And I write boom, because it's like, yeah, because they're alleging that this happened after 3:30. So you're taking Jennifer McCabe out of the equation of being one of those people to relocate him. She's automatically out, because we have her data. But I said, but this you can argue and say, no. It's not true though for Matt, because we don't have his data, his phone location. Okay. And he 1000% could have left with like a Higgins, could have picked him up, and you would need his phone. But So this argument to add to include her husband, no. You can 1000% make the claim with Miss McCabe, absolutely. Because her phone is there, her watch is there. She's at the house. She cannot be involved in that relocation. So now, Brian Albert. Mr. Albert previously lived at 34 Fairview, is married to Miss Albert, told the police that Officer O'Keefe did not enter his home on January 29, 2022, and testified against Miss Reed. There is no specific allegation that Mr. Albert relocated Officer O'Keefe's body. As a result, just like his wife and the McCabe's, every claim against Mr. Albert is based solely on his petitioning activity and should be dismissed under the Anti-SLAPP statute. Also, you guys, these people, when they were asked, was anybody arguing? Did Karen Reed look fucked up? No. Nobody was arguing. Everybody was great dandy, right? They weren't dogging on Miss Reed. They truly weren't, right? Unless they were, but they were like, listen, we have to write up the reports like this because we can't be influencing and saying X, Y, and Z. I don't see that though. But the butt dials, that shows conspiracy to me. So we'll see. You can see where the House defendants are staying away from certain things. And so I'll show that. So the only unique allegation against Mr. Albert is that he, months after Miss Reed was arrested and indicted, allegedly destroyed his phone, which Miss Reed alleges that eliminated potential incriminating communications. Albert, quote unquote, caused Miss Reed's wrongful indictment, arrest, and prosecution by destroying or discarding his phone. Much like Miss McCabe's alleged Google search, however, this allegation is false and a red herring. This purported conduct has no relevance to the elements of any claim asserted against Mr. Albert. For example, whether Mr. Albert destroyed his personal cell phone, the characterization of which is disputed, is not relevant to Miss Reed's malicious prosecution claim, as it does not relate to the initiation of Miss Reed's criminal proceedings. And I'm right over here. I'm like, well, if group text messages were known prior to June of 2022 and 2023, would this have helped Bev to grant that order? Okay. So now here's the $1 million question. Why didn't Karen Reed's defense team motion for a Franks hearing? I've always wondered this, right? Because it's going to come down to, as we continue to read, we're going to get into this whole, was there probable cause? Okay. And so I've always wondered, why did they never go the Franks route? Well, I think I got my answer finally. And I'll tell you when we continue to read here. Kimmy Love and stuff. Yes, all of that's true. Okay. I want to read this footnote here. Again, the complaint needs to be against the police, right? The police needed to get more information. The police didn't, right? Well, is that on the citizens or is it on the police? And now what do you do when the police, though, are actually also the citizens? Lisa and Canoy says, Lana, you're doing a fantastic job. Keep up the amazing work. Thank you so much there, Lisa. Appreciate that. Hit the thumbs up. Get the get the lawyers over here and they can start taking logic with our lawyering. Okay. So here, while not relevant to the court's inquiry on this motion, the evidence will show that Miss Reed's phone destroying contentions, both with respect to Mr. Albert and Mr. Higgins, are knowingly false. And I said, wait, what? I said, how are they knowingly false? Because they destroyed their phones, like that, just that claim period. And let me tell you something. Lally, if this is true, because we're going to get to a couple more pages down, if this is true with what they're saying Brian Higgins did, Lally is an absolutely piece of shit at his job, because he didn't know the case, didn't take the time, and could have, with all of these witnesses, there was ways to rehabilitate these witnesses. And what it seems to me, if these claims are accurate in here, or these, basically these, what the Commonwealth witnesses are asserting here end up being true, then if I'm the Commonwealth witnesses, I would be motherfucking Adam Lally and what was it, McLaughlin, so hard, because they did them no favors. Because you didn't, after they got cross-examined by whoever it was, if it was Alan Jackson, depending on the witness, Adam Lally should have known how to come back with shit. And he just didn't. And he left these witnesses out to dry. So now, oh, you sent Yuri's. Did you get it? Oh, I'll check. Thank you so much, Murky. Okay. Oopsies. Thanks, Merks. Appreciate you. Further, the amended complaint conspicuously omits that Miss Reed did not have a right to any information on Mr. Albert's phone in connection with her 2022 arrest or her 2024-2025 criminal trials. Mr. Albert had no duty to give it to Miss Reed any alleged incriminating evidence, did not receive a subpoena for those records, and was never ordered to produce any phone records to Miss Reed. On the contrary, on October 5th, 2022, Judge Canone denied Miss Reed's motion for a subpoena to access Mr. Albert and Mr. Higgins' phones, finding that the court is not satisfied that the requested phones contained information that is evidentiary and relevant. And if it would have been a more prepared motion and written better, nor is the court satisfied that the application is made in good faith and is not intended as a general fishing expedition. Well, pull up that motion that they wrote, that the defense wrote. Remember how we were all in the dark about Karen Reed and Higgins' relationship? Can you imagine if maybe that would have been used by the defense to get this material? It wasn't. The fuck? Why isn't Karen Reed telling her defense attorneys about it? Right? I don't know. Kimmy, love, and stuff. Lana is very intelligent. She can see through the lines of BS. Absolutely. And guys, from both sides of the attorneys, all day, every day, you have to understand that attorneys lie every time they talk. Sorry. And from both sides, you're going to get it. And just ixnay the fluff shit. Okay, let's keep it here. But they got to make their money, So I wonder why wouldn't be more of a push with talking about. So I would love to read what they filed again. So here we go. The court did so again on June 20th, 2023. That's when the wheels went off for Aiden. when this happened. The court did so on June 20th, 2023. There, the court held that Miss Reed had not shown with credible evidence that relevant or admissible evidence will be found on Albert's cell phone or in his cell phone records. Furthermore, Mr. Albert was never found to have violated any court order, nor was he, like the other Commonwealth witnesses, ever investigated or charged with perjury. You want to know what they make a big deal about? That a different agency came in and investigated this, and there have been no arrests to date. It's a pretty big fucking like gut punch. Sorry. It's not good. But do I think that she has claims against the police? Fuck yeah. Absolutely. But do I think that this is going to be difficult? According to Ms. Reed's allegation that Mr. Albert destroyed his personal phone has zero bearing on the actual claims she brings against Mr. Albert and does not defeat Mr. Albert, showing that her claims are based solely on Mr. Albert's petitioning activity. So again, he's saying, dude, this is all based on me being a witness and I should be protected by absolute immunity and SLAPP, and unless you can show, and I'm just over here like, if you would make different allegations, then you could potentially win this type of shit. Because I think it is a big deal that vehicle is missing, but that's not even being talked about. One should ask the defense or the plaintiff here, Karen Reed, why. I would take the word forward edge and remove it from your vocabulary because it's crushing you. Now we get to Brian Higgins. Mr. Higgins was at 34 Fairview on January 29th, and when interviewed by police on February 3rd, told police that Officer John O'Keefe did not enter the home. Now, I think that someone like a Higgins should be testifying in a manner to say, well, when I was there, I didn't see him. You know what I mean? Like, I have no idea if he went to the house. When I was there, I did not see John. In fact, I texted him. He never texted me back. I texted Karen earlier in the night, and we can get into all of that because that little hussy was trying to get me to play Dip the Stick. But I texted her, I texted him, and actually neither one of them had messaged me back. And then I had left, and by the time I left, I hadn't seen them. So, but I don't think he could outright come out and say that John O'Keefe didn't enter the home. The reason being is because he supposedly wasn't there that long. So, similar to Mr. Albert, Miss Reed. Now, remember what they're all leaving out, though. These butt dialing phone calls. Okay. So, do I think that can go to the conspiracy claims? I do. They definitely have communications, right? And take out if they lied or whatever their testimony was. That's an action. He goes to the police department, gets a big duffel bag or whatever the hell he was doing, right? Yep, those are actions. Goes into the police station where Sean Good was. Those are actions. The police and the prosecution keep those videos from the defense. These are actions. So, similar to Mr. Albert, Miss Reed alleges that Mr. Higgins destroyed his personal cell phone. Well, should this case proceed to discovery, the evidence will show that Mr. Higgins actually preserved his original phone and retained it for approximately 3 months after learning that the state court issued a preservation order and denied Miss Reed's motion for a subpoena. And I'm like, wait a second, what? And so if we think back about remember when Higgins was getting so frustrated when Alan Jackson kept wanting to talk about the phone and the SIM card being destroyed? But none of that would matter if he actually preserved his cell phone data in a different way. and this is where I blame Lally, because on redirect, he fucking does nothing that I can recall that sticks out to me to propel this opportunity because read these words, okay? Read this shit. Should this case proceed to discovery, because right now it's in a stay with discovery after this anti-SLAPP shit was mentioned, the evidence will show. This is a very, very big, bold claim. The evidence will show that Mr. Higgins actually preserved his original phone and retained it for approximately 3 months after learning that the state court issued a preservation order and denied Miss Reed's motion for a subpoena. Now, don't you want to hear more about that? I know I do. I'm looking forward to that. I'm in the business of truth, okay? It's period. For the same reasons described above, this allegation is not related to any of the counts that Miss Reed asserts against Mr. Higgins. Indeed, the amended complaint admits that Mr. Higgins maintained his old phone until at least October of 2022, months after Miss Reed was arrested and indicted by a grand jury. Thus, even assuming that Mr. Higgins, now remember, we wanted to know, was it 2022 or 2023 that they attempted, when I say they, the Reed defense team attempted to go to talk to Mr. Higgins? And I wanted people to double check, was that 2023 or 2022? Because I find it so ridiculous and hard to believe that they would, in 2023, even venture that. Now, in September of 2022, that would make way more sense. 2023? So I'm curious of that, and I think we wrote on one of the people's channels, like whoever was putting that out there. I just want to know more about that. Thus, even assuming that Mr. Higgins destroyed his phone at that time, which is disputed, that act could not have contributed to law enforcement's decision to charge and prosecute Miss Reed. And that's the facts, because that wasn't the reason that they prosecuted Miss Reed. Therefore, it does not prevent application of the anti-SLAPP statute. Mr. Higgins is also included in the group pled allegation that one or more of the Commonwealth witnesses relocated Officer John O'Keefe's body. Yet, similar to the allegations against Miss McCabe, Miss Reed admits in other portions of the amended complaint that Mr. Higgins left 34 Fairview hours prior to when she claims that Officer O'Keefe's body appeared on the front lawn. But in my contrast back to that, basically Karen, in her verified complaint, when she's going to be filing this verified complaint that's going to be coming next, she will go in more detail about that and said, no, we just said that he went to Canton Police Department. We never said that he did not go back. Okay. So that's going to come out. The next thing that's going to be happening here is Karen Reed's going to be filing a verified complaint. And I hope to God that verified complaint is way better than the last thing that she filed. Yes, I need Brian Tully's too. So Mr. Higgins is seen in the parking lot of CPD at 1:30 a.m. Nobody on the front lawn of Fairview at 2:30 a.m. because that's when, what's his name, went plowing by. Miss Reed cannot meet her burden of showing that each of the Commonwealth witnesses had no factual or legal basis for their petitioning activity. So because the Commonwealth witnesses have satisfied the first prong of the Bristol framework, the burden then shifts to Miss Reed to show that the Commonwealth witnesses' exercise of their petitioning rights was devoid of any reasonable factual support or any arguable basis in law. And this is where my argument strongly is in. So this is a difficult task because the mere submission of opposing affidavits and credible challenges are not enough. Miss Reed cannot meet the standard. Indeed, She cannot provide any genuine evidence to dispute the factual basis for the Commonwealth witnesses' petitioning activities, much less satisfy the higher bar of establishing that their activity was devoid of any reasonable factual basis. Foremost, Ms. Reed complains that each Commonwealth witness told the police and testified to the same that Officer O'Keefe did not enter 34 Fairview on January 29th. Each Commonwealth witness has submitted a supporting declaration attesting to the fact that they made those statements to the police and that those statements were truthful. See declarations of all of them. I was like, oh shit, okay, they have declarations. Miss Reed cannot rebut that or show that any petitioning activity was devoid of a factual basis, since this is exactly what Reed told the police on January 29th, 2022. And this is where I just completely went off. I said, if Karen Reed says 34 Fairview wasn't really 34 Fairview, Karen would meet this burden. You guys understand that, right? Make, man. God, don't you just love when your arguments are better than lawyers? I do. And it fits the evidence. Sorry, but so again, Karen Reed says it herself that John O'Keefe never went into the house, just like they did. And that on its face should make everybody scratch their head. Because it was only later that Karen Reed, right, came out and said that she saw him go in one of the two doors. Now, what you're going to argue is that Officer Michael Proctor, who was terminated in this case, is the one that wrote that police report, and that's not what I said. Right? Right. That's how you're going to argue it. But besides Miss Reed's own statements and then that were unrecorded by fired Proctor, so there's no weight in that shit, to the police, other evidence established that Officer O'Keefe never entered 34 Fairview. As reflected in the Commonwealth statement, Officer O'Keefe was found covered in snow on the front lawn of 34 Fairview, but no snow was found underneath his body. You need to use the pictures from Canton Police Department. Okay? There is no outline of a fucking body laying out there. There's just grass. You need to show the evidence of them blowing with the leaf blower. There's snow everywhere. The fuck are these people talking about, right? You need to use that. You need to go straight to that. And if you don't, fuck Karen Reed, then you shouldn't win. Okay? It's in these police department pictures. It's in the video of them blowing with the leaf blower. It's in the dash cam. So present that and say that that's not true. The evidence doesn't reflect that. I don't give a fuck what the Commonwealth statement was and put out by Morrissey, because it's not right, right? This evidence is consistent with Officer O'Keefe being injured at the time Miss Reed dropped him off prior to the blizzard conditions. Further, there was no evidence, I said, because the scene wasn't documented properly, no photos, video, diagrams, scene crime, scene log, roped off properly. You have to write all this shit. That's why because they're trying to say there was no evidence of any foot tracks in the snow between the home at 34 Fairview and the location of Officer O'Keefe's body. What you want to show is the dash cam video of Lank and Good coming out of that house, which is caught on the dash cam, and shown that there's clearly these two dudes are running across the lawn. Okay. And the pictures that were taken by Canton Police Department, it was taken after they ran across the lawn. All right. So there was clearly prints going across, just to show the mere fact that, like, that's ridiculous. We're unable to show any of this stuff. They can't even make that claim because nobody followed protocol. We don't have evidence either way to make that statement. But you could use the caddy that was parked there and no more, and it's not there anymore. You could use to show that you can't even see the lines of that car leaving, because all you can see is McCabe's vehicle going in, his SUV. I said, and you can make a nice strong argument with that as well, that you can't go off of because of the snow. But it's just, I just don't think that this argument should fail on either side because there is no evidence strong enough to support it. So it should just be taken out. That's what anybody with a brain would do. You could sit here and argue, but I would argue it both ways to show being genuine about it, and to say that we don't believe that a jury or a judge should be weighing anything like that with this, because it's just unreliable. If someone had relocated his body from the home to the lawn sometime after 3:30 a.m. in the middle of a blizzard, there would have been significant tracks in the snow between the home and the body. That's absolutely ridiculous. Okay. And I would use Nicole's missing SUV, not in the driveway, and missing altogether, and that there are no tracks. Like I just said, I would use the dash cam to show that Good and Lank ran across the lawn. Also, I think there are steps if you look at the leaf blower video really close. Moreover, Officer O'Keefe was found missing one shoe. Exactly. And what you would do is you would show the pictures that Canton Police Department took and that the shoe was not there. According to the trial testimony, the missing shoe was located hours later under snow next to the curb where Miss Reed dropped off Officer O'Keefe. You would put those two pictures next to each other, and you would show that the shoe was not there when Canton Police Department was there, blowing everything around. Just like they didn't find the hat, the shoe, the glass pieces, nothing. Fuck Kevin O'Hare and his testimony. I don't give a shit. In addition, Officer O'Keefe's shoe was found near pieces of broken taillight. Show Canton pictures and then put them next to it. That's all you got to do. It's good enough. The same angle. The shoe's not there. And it actually, I would go as far as to say, the couple pieces of red taillight that were found with the shoe, that to me is what you want to go after for the House defendants. Mainly Higgins, mainly Matt McCabe. Those are the two people. Because during the time that Karen Reed's vehicle was at the house, like nobody's around it, that's when a couple of the pieces were got, and the shoe and the pieces were planted together. And that couldn't have come from, in my opinion, Proctor. So if you want to be roping up the House defendants on stuff, you need to show how that vehicle was accessible and that that's where the Ring camera deleted videos from. And why would Karen Reed want to delete those videos? Also, Paul Gallagher had a very strong relationship with Brian Higgins, and he went to the wrong address, which was John's, and he tried to cover that up by, where am I supposed to? I thought I was supposed to go over here. He testified to it in trial 1, and he went to One Meadows. And he had to say that because in case the Ring camera footage couldn't have been deleted. And Paul Gallagher and Brian Higgins were very, very close. They did ATF shit together. So please, ridiculous. Start connecting dots. But they put everything on Proctor. They said Proctor did all the planting, and he just didn't. Proctor was used to cover it up by looking the other way. Moreover, officers Officer O'Keefe's cell phone was found underneath his body. At the second trial, the Commonwealth presented GPS data from Officer O'Keefe's phone that showed his cell phone ceased moving at approximately 12:32 a.m. at the same location where his body was found. Testimony from Ian Whiffen with relevant testimony. Further testimony revealed that Officer O'Keefe's phone locked for a final time at 12:32 a.m., meaning that Officer O'Keefe did not access his phone after that time. Ms. Reed alleges in her amended complaint that Officer O'Keefe's Apple Health data showed he had just enough distance to get from the driveway to the house or into the house. And I have no idea why they fucking wrote that. The problem here is that Officer O'Keefe and his phone were found by the flagpole on the front lawn. Thus, even disregarding plaintiff's misrepresentation of the Apple Health data, the fact that there was just enough distance to get into the house cannot account for Officer O'Keefe's location back on the front lawn hours later. You need a Faraday bag to do that. And even if there is some dispute about the number of steps taken by Officer O'Keefe, that would not be sufficient to satisfy the burden of showing that the petitioning activity lacked any reasonable basis in fact. So, Ms. Reed also claims that Ms. McCabe falsely told police that Ms. Reed made inculpatory statements the morning of January 29th. But again, Ms. Reed cannot meet her burden that those statements to police, her petitioning activity, were devoid of any reasonable factual basis. On the contrary, the Commonwealth statement identifies that several other individuals heard Ms. Reed make incriminating statements on January 29th. For example, on January 30th, police spoke to Canton firefighter Katie McLaughlin, but she didn't write a report. Okay, and that was a day later, right? But when was the report written? Just because they spoke on the 30th, when was the report written? Give a fuck about spoke, so they need to focus on that. These key words, you need to point out that January 30th, fuck your speaking, okay? But it also says police spoke to Canton firefighters. Who? Miss McLaughlin spoke with Miss Reed at the scene and heard Miss Reed state repeatedly, I hit him. Accordingly, because each Commonwealth witness has shown that Miss Reed's state law claims are based solely on petitioning activity for which she cannot establish the absence of any reasonable factual basis, each Commonwealth witness is entitled to dismissal of those claims and award of their attorney fees. The case against the Commonwealth witnesses should be dismissed pursuant to Federal Civil Rule 12.6 or 12b6. On a motion to dismiss, the court must determine if the facts alleged plausibly narrate a claim for relief. First, it must distinguish the factual allegations from the conclusory legal allegations. Factual allegations must be accepted as true, while conclusory legal conclusions are not entitled credit. Second, it must determine whether the factual allegations present a reasonable inference that the defendant is liable for the misconduct alleged. So, all claims brought against the Commonwealth witnesses are shielded by the doctrine of absolute immunity. Ms. Reed's original complaint only hinted that her claims might be premised on the Commonwealth's witnesses' prior testimony against her. The amended complaint now confirms it beyond question. Controlling law based on precedent dating back centuries is unequivocally clear that claims of this nature cannot survive. It is well established that the immunity of parties and witnesses from subsequent damages liability for their testimony in judicial proceedings is absolute. The immunity extends to all persons, governmental or otherwise, who were integral parts of the judicial process. Without it, the truth-seeking process would be impaired. Witnesses might be reluctant to testify, and even if a witness took the stand, the witness might be inclined to shade his testimony in favor of the potential plaintiff for fear of subsequent liability. Here, the amended complaint expressly references and relies on the Commonwealth witnesses' testimonial activity over a dozen times. Indeed, each claim brought against the Commonwealth witnesses directly alleges that, one, they coordinated to tell investigators that Mr. O'Keefe never entered 34 Fairview, and that Miss Reed made inculpatory statements on the morning of January 29th. Some of them provided false testimony at Reed's criminal trials. 3, Miss McCabe lied to a separate law enforcement agency. How come they didn't charge her then? Like, they're not doing Karen Reed any favors. Why didn't they charge her? These allegations, having occurred during the investigation and prosecution of Miss Reed, are protected by the absolute by the absolute, where the fuck was I? These are protected by the absolute privilege because they were pertinent to judicial proceedings as a matter of law. Moreover, it is of no importance that Miss Reed alleges that Miss McCabe lied to the separate law enforcement agency, or that some of the Commonwealth witnesses rendered false testimony during Miss Reed's criminal trials. None of that matters. This is what I want to know, if it's true or not. While those allegations are vigorously contested, black letter law is clear that statements made in relation to a judicial proceeding are protected even if uttered maliciously or in bad faith. Like, holy fucking shit. As detailed, damn. In sum, the allegations made in support of the elements of each of Miss Reed's claims are based on statements made during Miss Reed's criminal trials or to law enforcement officials in the context of Miss Reed's arrest, indictment, and prosecution. Because such allegations are protected by the absolute immunity doctrine, the claims they purport to support must be dismissed. Now, this is where you have to focus on any possible action of these defendants in this that were the actual House, they're the Commonwealth witnesses. You need to solely focus on action, because what it seems to me is that fuck all with these people, what they testified to, and I don't care how ridiculous it was, how much they lied, nothing can happen to them. Hoo-wee. The last part I'm going to talk about with this is the time bar. I lost my shit. I want to know if these are going to get tossed because of this. So a couple of these have a 3-year time limit. Okay. So they are all subject to 3-year statute of limitations that have expired. And I said, well, it depends on when Karen Reed got discovery. Because just because this happened in January of 2022, when does Karen Reed reasonably know that these people did X, Y, and Z? So you have to look at, just because it's when the discovery truly was given to Karen Reed. And the question then even can become is, just because Karen Reed's defense team received the discovery, did that mean that Karen Reed received it? Okay. Because, for example, Dan Moore in his when he was dealing with all of his criminal defense shit, when he was charged with the murder of Ryan Drake, he didn't receive the criminal discovery. He didn't receive any of the material. His lawyer did. And so therefore he didn't have access to it. He wasn't looking at it. His lawyer was doing all of this shit. So just because, and it's important to mention that, because can that be made as an argument? For example, for all 4 claims, the limitations period begins to run when the plaintiff knows or should know that she has been injured. Knowledge that an injury had occurred. So all of the facts necessary to make out her civil rights claim. And so right away I said, well, we need to figure out these discovery dates. But then even based on the discovery dates, when did just because you're given some, it doesn't mean you even had the opportunity to open it, go through it. Like, what's up? Was it? So you would argue this because they lay it out that even assuming these allegations were true, some of the Commonwealth witnesses vehemently deny, but let's just say they're true. The claims are time barred because Miss Reed was aware of those purported efforts long before November 17th of 2022, because that's would be the absolute latest that you could, because of the filing. So, and I said, well, is this true? Let's find out. And this is the 3 years before Miss Reed filed her original complaint in the state court. So publicly available information docketed during the underlying criminal trials, which the amended complaint incorporates by reference, confirms that Miss Reed's awareness. For example, on June 10th, 2022, that was the day after she was indicted for second-degree murder, Miss Reed obtained a trench of discovery from the Commonwealth, including the Commonwealth witnesses' statements to police, which the amended complaint alleges was when these individuals told law enforcement that Officer O'Keefe never entered 34 Fairview. Because that's the big lie. But it sucks when you're saying that Karen Reed said the same thing. Like, it's like a fucking horrible argument. You need to say that she thought it didn't. I didn't get to watch him go in, but I can tell you right now that wherever the fuck we were was not at 34 Fairview. I'll tell you that. But also, on June 10th, 2022, Miss Reed acquired extraction data from Commonwealth witness Miss McCabe's cell phone. Now, what they can argue here is that we didn't hire the guy to go through any of this until this date. You know what I mean? So I think that they can make some really good arguments here, in my opinion. We didn't, just because we got her extraction, we didn't. I'm not an expert. I can't go through any of that. I don't even know what any of that shit fucking means. You know what I mean? So when did Richard Green get hired on and start looking through it and explain what her phone had, you know? So I think they're going to be able to make this date's going to get kicked because that's ridiculous. It's going to go based off of when somebody can actually read the material that knows how to open it and use it. So indeed, the amended complaint goes so far as to allege that the Commonwealth witness, Ms. McCabe, was the point person in the efforts to coordinate the alleged statements of police, bolstering the significance of the data that Ms. Reed has had since June of 2022 to her overall theory of the case. Ms. Reed even used this June 2022 evidence to support a Rule 17 motion filed on September 15, 2022, wherein Miss Reed argued the exact same theory that she presents here in this instant case. And I was like, oh, fuck. So I don't know. Like Miss McCabe's cell data, Miss Reed's September 2022 Rule 17 motion is incorporated by reference in the amended complaint and is therefore appropriately considered at this stage. But that was for Brian Albert shit. The amended complaint set forth one other allegation in support of the conspiracy, namely Mr. Albert and Mr. Higgins' reportedly efforts to destroy their phones, but that allegation cannot cure the time bar. So I think Karen can. I said right here, her defense received this. Does that matter versus when she received it? And did she think that she would be harmed? When did she realize that she was harmed by it? If she's thinking like, we have this motion to dismiss set, this is when this is going to happen, so I didn't know that I was harmed until when it didn't get, dismissed. Okay. So this attorney, I kind of like this attorney because they talk about things in the motion that the best case scenarios, if you want to say that Karen Reed, accordingly, the only civil rights violation that the Commonwealth witnesses are alleged to have infringed upon is Miss Reed's Fourth Amendment right to be free from wrongful arrest. Absolutely nothing in the amended complaint, aside from their protected testimony offered against Miss Reed, affirmatively connects the Commonwealth witnesses to the prosecution. And courts do not hesitate to parse out civil rights claims that are generally associated with both wrongful arrest and wrongful prosecution when analyzing a statute of limitations defense. Those cases are clear. While claims associated with wrongful prosecution occur after the termination of the underlying criminal proceeding, claims associated with wrongful arrest do not. And as discussed above, any effort to retrieve or to revive Miss Reed's otherwise untimely claims by relying on the Commonwealth witnesses' statements made throughout and in anticipation of Miss Reed's criminal trials should be swiftly rejected, since such testimony is shielded by absolute immunity. In sum, Miss Reed was fully aware of the pertinent facts underlying her conspiracy, MCRA, IIED claims before November of 2022. The fact that she was acquitted in June 2025 does not save those time-barred claims. So, indeed, the only relevant allegation that this purported conspiracy continued for years after Mr. O'Keefe's death are that Ms. McCabe lied to separate law enforcement agencies in April of 2023 and spoke with other law enforcement officials in anticipation of Ms. Reed's trial in September of 2023. Activity that is similarly barred by absolute immunity. Moreover, the allegation that defendant Buchanan fundraised for the Commonwealth witness is a red herring, since the amended complaint concedes that such efforts took place after Ms. Reed's June 2025 acquittal and therefore could not be component of conspiracy to have Miss Reed prosecuted. Well, I want to show you guys what I was able to say. Could you go this route? Miss Reed fails to allege that the Commonwealth witnesses took an active role in her investigation or prosecution, and she does not assert that they induced or pressured law enforcement to arrest Miss Reed in any way. Well, what about this conspiracy to commit witness intimidation with Aidan Carney? Were they calling for her arrest, right? And that happened way after the fact and was an ongoing thing. So could Reed's defense team use that date and any type of communications with these Commonwealth witnesses that were trying to get her potentially charged with more? Could you go that route? Again, this is me trying to get creative, right? The meeting at the Proctors. So the only interactions that the Commonwealth witnesses are accused of having with the investigation and the prosecution are through their witness statements and trial testimony. And I'm over here like, well, what about the meeting at the Proctors? Such is wholly insufficient. I think the meeting at the Proctors, I don't know. Ms. Reed fails to assert that what was discussed at those meetings, though, or more notably, that such meetings influenced Ms. Reed's prosecution or induced Proctor or Lang to do anything at all. Well, conspiring to get new charges, the witness intimidation ones, I think that that's obvious when they set a grand jury. There are simply no allegations that the Commonwealth witnesses, for example, pressed the police to apply for a complaint. And I think that right there, if you're the defense, you need to consider that. Again, this is me, How would I go about it? Well, I'd be asking my attorney about stuff like this. I mean, weren't they demanding or directed the police to arrest Miss Reed? And I would think that, yes, they were with the witness intimidation charges, the conspiracy to commit witness intimidation. Wasn't it Proctor that wrote and said, why aren't we arresting these people? Why aren't we arresting Aiden? I don't know. I'm sure that they were saying the same thing about Reed. Tellingly, the amended complaint is devoid of allegations that the Commonwealth witnesses harbored any personal animus towards Miss Reed or even implicated her in Officer O'Keefe's death. Merely reporting that Officer O'Keefe did not enter 34 Fairview cannot reasonably establish that the Commonwealth witnesses acted in a manner that commenced or continued Miss Reed's criminal proceedings. I said, look at Lana's list of things that should have been included, and you wouldn't even fucking be here. Moreover, Miss Reed fails to state that the charges filed against her were made in reliance on the Commonwealth's witnesses' statements. The amended complaint, as well as publicly available information incorporated by reference, outlines a vast amount of other evidence used to charge Miss Reed, all of which the Commonwealth witnesses had no role in. I would say that you would show, if you're Karen Reed here, you're going to show that it actually did have a role. The shoe, the wellness check, the Ring camera, the deleted footage, the actual calls by BA and BH at 222. Those are all actions. Okay? Those are all actions that were done by, and you want to put on the House defendants. Again, in my opinion. Now, Miss Reed fails to establish an absence of probable cause. So this is where I wondered if why they never talked about going for Franks was because of this. Probable cause is defined as such a state of facts in the mind of the defendant as would lead a reasonable person lead a person of ordinary caution and prudence to believe or entertain an honest and strong suspicion that the plaintiff has committed a crime. So this is important because what they're about to say is, in this instant case, any reasonable person would have suspected Miss Reed's culpability. And it's like, unless you know what happened to John O'Keefe, right? So, this is just at the stage of probable cause. So, for example, they say Miss Reed admits to being outside the home in the early hours of January 29th in the area where the body of Officer O'Keefe was found the following morning. I said, not if at a different house to drop John off. I'm over here stuck, guys, in my way. I'm not getting off my hill. Like, never. Like, I'm sorry, but every time they make an argument, this argument trumps it all. It is undisputed that Miss Reed's taillight was cracked when Officer O'Keefe's body was discovered. But I think it's disputed on when people knew about that. Miss Reed admits to seeing Officer O'Keefe's body almost immediately the morning of January 29th, notwithstanding the darkness and blizzard conditions. And a secondary independent investigation was conducted that resulted in no additional arrests, undermining Miss Reed's theory that the fact development was entirely controlled by the defendants. Said, well, the FBI doesn't arrest for state crimes, though, right? The FBI has to come in. If they, how they were able to go about it with Sandra Birchmore is because they labeled her a witness, and then they found a way to do the whole wire transfer, like wire fraud, because he was on the clock and banging, and he shouldn't have been getting paid, and he was getting paid by like a wire transaction. I would hate to see Karen not be able to make her claims because of some statute of limitations. The amended complaint also intentionally omits critical facts that were available at the time Ms. Reed was arrested and prosecuted, and which further supported the probable cause determinations. The Commonwealth statement notes that Ms. Reed admitted less than 12 hours after finding Officer O'Keefe's body that she did not see him enter the residence the night he died, which is consistent with the statements made by the Commonwealth witnesses. Additionally, medical professionals told law enforcement that Ms. Reed stated on various occasions on January 29th that she may have hit Officer John O'Keefe with her car. Collectively, this is sufficient for a reasonable person to find probable cause. A court may consider matters of public record, including documents from prior state court adjudications, in deciding a Rule 12b-6 motion to dismiss. Those same reasons why the malicious prosecution claim fail under the prior two elements demonstrate how Ms. Reed fails to show that the Commonwealth witnesses acted with actual malice. No actual malice where there was probable cause. I said, if they knew the truth, isn't that malice? That's, you know what I mean? That to me is, they're not that. I'm not talking about there's no statute of limitations for murder. Listen, they need to attack Karen Reed's team needs to have a fucking meeting of the minds, and they need to just focus on the acts of each and every single person that they are accusing this of. Okay. That's what I would be doing. I'd be focusing on the acts. Like, what were these people doing? Their actions, not things they said. Okay. Their actions. That's just my opinion. Now, this is the conspiracy shit. The amended complaint fails to allege any coordination between the Commonwealth witnesses and any state actors. And I'm like, wait, they didn't? Even reading the allegations in the light most favorable to Ms. Reed, the amended complaint only alleges that the Commonwealth witnesses coordinated their efforts through text messages and phone calls amongst themselves. There is no allegation that any of them communicated with law enforcement outside of the statements they gave in late January and early February. But I think your argument here needs to be that they are law enforcement. This is a very unique situation, Your Honor, because they're not just citizens; they're also government workers, right? They are law enforcement. I mean, Brian Higgins is basically a Canton police officer. So my comment is, but these witnesses were government. They were law enforcement people. So, so when I went back and checked, what they're claiming the conspiracy is they're adding in Courtney. They're adding in Julie, Albert, Courtney. And they're saying that those people were used. as third party. And so they talk about this here, and it says, okay. And while Miss McCabe is now alleged to have visited defendant Proctor's home in September of 2023, the amended complaint lacks any allegations by which this court could reasonably infer that such visit established the type of relationship necessary to confer state action. The confusing proposition that Proctor, Buchanan, and Tully somehow coordinated with the Alberts and McCabes through Proctor's sister, Courtney, who communicated frequently with Julie Albert, does not salvage the claim. For the court to impute state action based on that assertion, it would need to find that an agreement between the Commonwealth witnesses and law enforcement was somehow established through 3 levels of back-channel communications involving 2 individuals who Miss Reed does not allege participated in the conspiracy. Notably, the reader is left to guess what confidential information Courtney Proctor purportedly shared with Julie Albert, and what Julie Albert then purportedly shared with the Commonwealth witnesses. While Miss Reed may be afforded reasonable inferences, this theory of coordination simply asks the court to fill in too many gaps. And in Karen Reed's defense, no, they need to focus on the fact that there was timelines that were being asked to be drawn up. Like, the word timeline was used to build a timeline. Okay. While Miss Reed may be afforded reasonable inferences, this theory of coordination simply asks the court to fill in too many gaps, just like a fucking Saturday night at a strip club, right? Common law conspiracy. Plaintiff's common law civil conspiracy claim fails since the amended complaint fails to state a claim for the underlying tort of malicious prosecution. Nonetheless, assuming arguendo that the malicious prosecution claims survive, the amended complaint still fails to plead facts sufficient to establish a common law conspiracy among the Commonwealth witnesses, meaning those 5. So to the extent that Miss Reed's conspiracy claim against the Commonwealth witnesses is premised exclusively on the theory that they conspired with law enforcement as opposed to conspiring amongst themselves, such claims should fail for the reasons outlined with respect to the 1983 conspiracy claim, namely that the amended complaint is devoid of sufficient allegations that the Commonwealth witnesses ever came to an agreement with law enforcement to commit a wrongful act. And I just think that this is one of those situations that they are law enforcement. I don't know. Moreover, regarding the allegations that Commonwealth witnesses came to an agreement to tell investigators that Officer O'Keefe never entered 34 Fairview, the amended complaint fails to allege that the Commonwealth witnesses knew that they were committing a wrongful act when such statements were made. And I think that that's why you have to say that they planted the shoe. Because then you would know the significance of that. Him never coming in the house means I don't know. I know why they put everything on Proctor, as he did all the stuff to, like I said, for this frame job, but unfortunately that's just not what happened. Proctor's an idiot, and Proctor covered it up, looked the other way. They went ahead and pinned it on the girl, and I'm just going to cover that up by looking the other way and not investigating. But I don't believe that Proctor was used in the sense that he was the guy that was sprinkling and putting evidence at the scene. I think other people were. That's just my take, because I believe that this, if you guys are going to sit here and say that this all started to begin at 2, you know, the butt dials and stuff like that, they really weren't butt dials, they were talking, then yeah, you need to put some on the people that knew about it and that he was already incapacitated. And we'll see. All right. I want to see what these people are saying that are the not House defendants. Hold on. We're going to switch gears. So what do you guys think? That's basically the end of it. Oh, Turtle Boy should really look up what threat means. It'll be interesting. Let's print this. Thank you for sending Murky. Oh, what's that? This is the Matthew Farwell shit for new DNA evidence. We'll print that. I'll print it off. Why were the butt dials only between them and not others who were spoken to possibly earlier in the day? Well, I think that's where you want to throw in the Matt McCabe and the Higgins, and Matt McCabe using Jen's phone. We've never seen Matt McCabe's phone. For all we know, Matt McCabe has phone calls with, I don't know, you know, something weird in my gut has always said with this case that it was like John O'Keefe opened up a door and went in, which would make sense, the garage, instead of going in one of the other. He went into the garage, and that nobody knew that he went in there, and that the dog was in there, and that the dog jumped up, attacked him, and then he fell back, hitting, his head, knocked him out, and he wasn't found, right, until they went to go look for the dog. Hey, the dog's in the garage. I put the dog in the garage. And then when they went, then that's when they found John. Okay. And it was like a pure panic. Like, what the fuck? Okay. And I think the reason that that's always been in my head that something could have happened is because John's phone completely stopping like that. And then people panicked that tried to, save his life, right? And then it was like, oh my God, people are going to think that we did something because maybe stuff's going through people's heads like, oh my God, Karen was texting me and blah, blah, blah. Like, I don't fucking know. Like, could somebody, but that would make, Jen McCabe calling over and over and over John like she did. It's like he's not there, right? Like, but she just saw him. Like he's walking up. Like, where the fuck are you? Like, and then she's calling him, and then she's looking out, and she's like, she's claiming all these things, right? But to keep calling and calling and calling. But when that calling and calling started was at 12:45 after she thought what she thought was Karen driving away in the SUV. That couldn't have been Karen, right? Because Karen's already at home. But somebody was driving away at 12:45. Somebody was in a vehicle that drove away. Higgins. I mean, okay, Buchanan's answer. 24 pages. There is simply no way OJO's phone is moved between 12:32 a.m. and 6:02 a.m. That's not necessarily true. If pocket state is determined by lights, I would love to know more about pocket state. But a Faraday bag, if a phone's in a vehicle and it was in like the glove compartment because it was thrown in like a glove box or something like that and shut. If it was put in like a middle console and shut, and then you're driving around with a phone in your car, the phone's moving, but it's not registering any steps, and it wouldn't register that it came out of a pocket state. So the pocket state was the first time we heard that was that trial. So I haven't had the opportunity to get raw data and look at that. It was because I was very, very interested in that. I was also very interested in the fact that at 12:29, Jen calls him and he answers that phone call at 12:29. But according to Jen, she's like, that must have been a butt dial. Well, if you're going to put all the weight in John's phone like you do, then you have to put the same weight in Jen McCabe's phone. Otherwise, that's biased. They both had the same type of phone, and Jen's phone is not indicative of her getting up and walking with her phone back and forth over to anywhere, because she does not take any steps with her watch from 12:25 to 12:35. And what it seems like to me is that Jen was in a vehicle waiting for like him to arrive, and she thought that he was there, and then I just don't think it was the vehicle that she thought it was, and then he pulls away, whatever. It's like this was a tragedy. It was like it was a tragedy, but a tragedy turned like, why didn't we call for help when we found him? I don't know. Because everybody had been drinking. I mean, sorry, I'm printing all this shit. I think just to consider that all these people, to include Karen Reed, right? And everybody's all fine at that bar. And then immediately we're going to sit here and say that one or multiple of those people completely turned into human garbage. And, knowingly left a man to die in the cold. I think there was just panic. I think there was drunk people, bunch of, and I don't know. I mean, when you find out in a trial that Higgins and Karen were having some type of thing, I mean, fuck. That's like, how did those two not become defendants together? In every other case that we would hear about, those two would become defendants because they tried to get rid of John. Right? I mean, mind-blowing to me. And it should be mind-blowing the fact that the Commonwealth didn't use any of that as a motive for her when she's the defendant. Why are they not using Higgins in some type of motive like of that? Like, I don't know. Okay, Yuri, we got his. Who else filed? Brian Tully's got his. Okay. All right. We'll go with Yuri. Yuri says, the allegations contained in these paragraphs 1 through 16 are introductory in nature and contain legal conclusions. Therefore, no response is necessary. To the extent a response is required, they are denied. Notwithstanding, Buchanan and his fellow Massachusetts State police officers or troopers conducted a comprehensive investigation which revealed ample probable cause to charge the plaintiff. Again, that key word there. Karen Reed for causing the death of Officer John O'Keefe by striking him with her vehicle. Now, to continue with that, with her vehicle. Ooh. The bulk of this section of the complaint describes a conspiracy theory not rooted in facts or reality. Okay. Well. So 17 through 25 is the parties. Then it goes to Mr. O'Keefe's death. So denied that Miss Reed consumed several drinks. Miss Reed consumed a minimum of 9 alcoholic drinks, far more than several. Agreed that Mr. O'Keefe and Miss Reed went to C.F. McCarthy's and the Waterfall Bar in Canton. Buchanan is without knowledge. Admitted that Brian Albert and Mr. O'Keefe were Boston police officers and that Mr. Higgins was an ATF officer. As to the remaining allegations, Buchanan is without knowledge. Buchanan is without knowledge. Buchanan is without knowledge. Denied. The investigation of this incident uncovered no evidence to support the allegations in this paragraph. $33 was that at some point after entering the house or garage, Mr. O'Keefe was involved in a physical altercation either inside the house or garage. During that altercation, the Albert's German Shepherd attacked him, and Mr. O'Keefe sustained multiple dog bites and scratches on his right arm. He also suffered an incapacitating countercoops wound on the back of his head. So that's all the stuff that he's saying he's denying. Let's see. Okay. The allegations in this paragraph refer to other defendants, denied nonetheless. 36. Buchanan denies that there was Mr. O'Keefe was either dead when the House defendants left him on the Alberts lawn or he died shortly thereafter. So he denied. Nonetheless, the investigation of this incident uncovered no evidence to support the allegations in this paragraph. The video reference in this paragraph speaks for itself, and further, the investigation did not uncover any wrongdoing by defendant Higgins. After the physical altercation, Higgins left the house and drove to the Canton Police Department in the middle of the night. He later told investigators he had to do some administrative work, but then changed his story. So he says the video speaks for itself, and further, the investigation did not uncover any wrongdoing by defendant Higgins. The allegations in this paragraph refer to other defendants, therefore no response is necessary. Nonetheless, the investigation of this incident uncovered no evidence to support the substance. After leaving the police station, Higgins and Brian Albert continued to coordinate their stories by calling each other multiple times in the early morning hours and ultimately spoke with each other on their cell phones at 2:22 a.m. Later, both Brian Albert and Higgins denied the existence of these phone calls. And then when confronted with the existence by a separate law enforcement agency, yeah. Okay. Okay. However, it is believed to be accurate that Miss Reed was the first to locate Mr. O'Keefe under inches of snow, as she was aware of his location. Which one? That's 40. What? Okay, so this is the paragraph 40 is about the Ford Edge, which had been parked in a position to obscure Mr. O'Keefe's body in the middle of the night, had been moved. Bunch of fucking idiots. The allegation in this paragraph refers to other defendants. Buchanan further states that the recording of the 911 call speaks for itself. Investigation begins. Admitted that the Canton Police Department were the first law enforcement officers on scene. As to the remaining allegations in this paragraph, Buchanan is without knowledge. Information. Nevertheless, O'Keefe's injuries were consistent with being struck by the rear end of Miss Reed's Lexus. The injuries were consistent. "43. It is admitted that there were several inches of snow and an active and ongoing snowfall at the time." This is about not a single piece of taillight material was discovered on the lawn or in the roadway that morning, notwithstanding multiple searches and the use of a leaf blower to remove snow. Buchanan is without knowledge and information sufficient to form a belief as to the truth of the allegations contained in this paragraph. Are you fucking kidding me? It is admitted that there were several inches of snow and an active and ongoing snowfall at the time. He does not know that not a single piece of taillight material was discovered on the lawn or in the roadway that morning. notwithstanding multiple searches and the use of a leaf blower to remove snow. He doesn't know that. See, this is where Karen Reed needs to put all of her fucking energy in and fucking slap these pieces of shit. Okay? Oh, thank you. My hair makes me look so young. I appreciate that. I can't believe, like, this is where I'd be focusing. I fuck these bad. This is where you're going to get paid. What's the next one? This cocksucker says. This is where all my energy would go. Tellingly, despite the commotion outside, including more than a dozen first responders, the 3 police cruisers, this paragraph contains an opinionated narrative made obvious by the fact that it begins with the word tellingly, which requires no response. However, no sirens were used given the early morning hour. Buchanan is without knowledge and information. All these people are a bunch of smart asses. .45 is about Sergeant Link was a longtime friend of the Alberts and the first law enforcement officer to enter the house. Buchanan is without knowledge and information sufficient to form a belief as to the truth of the allegations contained in the paragraph. However, as stated, it is confirmed that law enforcement entered the house. Okay. So here, Buchanan is denying that him and Tully were aware of any misconduct by Proctor in the handling of this investigation. As to the remaining allegations, they are denied. Wow. Proctor was assigned to the investigation according to normal procedure, as he was the on-call detective on that date. At the time of the assignment, Buchanan was not aware of any relationship between Proctor and any of the involved parties. Once Proctor informed Buchanan of a limited connection, Buchanan confirmed that there was no conflict requiring reassignment. As to the remaining allegations, they are denied. Proctor, Buchanan, and Tully engage in corrupt and biased investigation, but not investigating inside the house and interviewing house defendants as friends rather than suspects. Buchanan denies the allegations contained in this paragraph insofar as these investigatory steps were not indicated and insofar as their omission impacted the investigation. So that's 50. And that is Proctor, Buchanan, Tully, and the MSP never searched for DNA evidence inside the house, never looked for rigid surfaces that could have caused the gash on the back of Mr. O'Keefe's head, never inspected the house defendants' bodies for indication of bruises or cuts that resulted from an altercation, and did not search the house defendants' cell phones, with the exception of Jennifer McCabe. This allowed potential evidence to be destroyed, disposed of, removed, or simply become unrecoverable. And so Buchanan is saying that Buchanan denies the allegations contained in this paragraph insofar as these investigatory steps were not indicated and insofar as their omission impacted the investigation. Buchanan denies that the interviews of the house defendants were outside of normal protocol. Huh. I mean, is this for real? Buchanan admits that the interviews of the House defendants were not recorded. Buchanan admits that some House defendants were interviewed at their lawyer's office as required by the United States Constitution. As to the remaining allegations, Buchanan is without knowledge and information sufficient to form a belief as to the truth of the allegations contained in the paragraph. And that's paragraph 51. In paragraph 51, they were all interviewed either at their home, their family member's home, their lawyer's home. And so he doesn't make any mention as to the remaining allegations, Buchanan is without knowledge, information sufficient to form a belief as to the truth of the allegations contained in this paragraph. He's going to have a field day with that. But weren't you present for these interviews? Didn't you read the reports? These interviews were untimely, unrecorded, and fundamentally designed to protect the House defendants. See, this is why what you're supposed to do is you keep all emotions out and you just state things very simply because you want the person that's answering the complaint to be able to answer it. Because otherwise, if you get and say all this wordy shit and try to like, right here, was designed to protect the House defendants. Right there, you can just say, I'm denying that. Nothing that I did was to protect the House defendants. But if you don't fucking put that in there, then everything else needs to be addressed, right? I don't know. I thought that they teach you this in law school. Oh God. Okay, so 52. McCabe was wildly active. So he says the allegations in this paragraph refer to other defendants, therefore no response is necessary. Buchanan further states that there has been no evidence discovered to support any wrongdoing by Jennifer McCabe or any other witnesses. The record reference in this paragraph speaks for themselves. That was 54. Buchanan was not involved in interviewing Carrie Roberts at this time. Buchanan was not involved in interviewing Carrie Roberts at this time, and the text reference in this paragraph speaks for themselves. The allegations in this paragraph refer to other defendants, therefore no response is necessary. Okay. Number 60. This is about deleting text messages. Buchanan is confused as to why, as Karen Reed alleges, Miss McCabe would delete text to people not involved in this matter, but leave the so-called planning text for all to see if she had anything to hide. Many of the allegations in this paragraph refer to other defendants, therefore no response is necessary. As for the allegations that mention Buchanan, he did review Miss McCabe's phone records and found that she only deleted some text between herself and her daughter. Buchanan is confused as to why, as Karen Reed alleges. But the allegation says that the House defense deleted many of their texts among themselves and others in the aftermath of Mr. O'Keefe's death. He doesn't address it. Buchanan is confused as to why, as Karen Reed alleges, Miss McCabe would delete text to people not involved in this matter, but leave the so-called planning text for all to see if she had something to hide. Oh God. Look at this motherfucker. This is fucking crazy. 61. The plaintiff does not have expertise and experience in crafting stories to the media. Later, in another group text with Jennifer McCabe and Brian and Nicole Albert, Matthew McCabe suggested having Chris Albert publicize their crafted story to a reporter, saying, "Ask Chris to ask some questions. Tell them the guy never went into the house." As an endorsement of the plan, Brian Albert responded, "Exactly." The plaintiff, the allegations in this paragraph refer to other defendants, therefore no response is necessary. The plaintiff does have expertise and experience in crafting stories to the media. That's a dig on her and Turtle Boy. Buchanan, oh my God, 61. 62. Importantly, the text messages from the House defendants' phones that were ultimately recovered. God, Jesus Christ. Buchanan denies that he engaged in any unlawful investigation, that he was biased and or corrupt. As to remaining allegations, Buchanan is without knowledge or information sufficient to form a belief. It is unclear why plaintiff is not identifying such separate law enforcement agency while relying on such investigation, and importantly, notes that only an investigation was conducted resulting in no charges. So he wants to know why she has to. It is unclear why plaintiff is not identifying such separate enforcement agency. Dude, this is going to get wild. This is unbelievable. This is the snarkiest shit I've ever fucking seen. Buchanan admits, number 62, that an interview that the McCabe and Brian Albert was okay. Buchanan admits that he interviewed Nicole Albert, Brian Albert, Chris Albert, and Julie Albert. As to remaining allegations, Buchanan is without knowledge or information. Okay. Denied that Buchanan failed to conduct a meaningful investigation. Well, I think that you're going to lose there. Admitted that Buchanan interviewed Higgins and that Higgins presented some text between himself and the plaintiff. Further admitted that Higgins reported that he and Reed had kissed. Buchanan admits that he did not do further interviews with Higgins. Denied that Buchanan hid any videos. What videos? The plaintiff further cites the investigation of a separate law enforcement agency as evidence of misconduct, but once again fails to note that such investigation found no misconduct and did not result in any criminal charges. As to the remaining allegations, Buchanan is without. That's what I put in my thing. I said that's going to be a problem. This is crazy. Buchanan denies that he or any other state trooper did anything for the benefit of the House defendants, and states that he conducted a thorough and fair investigation. And charged the correct suspect, Karen Reed. This is fucking pour me a drink. This is oh my God. What the fuck am I reading? Yeah, Yuri, Proctor, and Tully are lucky that MSP conducted soft internal affairs investigations. Buchanan denies that he or any other state trooper refused to collect important evidence. How is he can deny on the fact of any other trooper? Like, he wasn't there with them. Further, Buchanan states that evidence that the MSP did collect was overwhelmingly demonstrated the guilt of plaintiff Karen Reed. They're all sticking together and hard. They don't care if this ruins their anything. Buchanan is without knowledge. Okay, no. By striking him with her vehicle. This is fucking crazy. And Turtle Boy thinks that they're not coming for his nuts. Oh my god, if I was Turtle Boy and I read this, I'd be like, oh fuck my life. Oh fuck my life. Oh fuck. Ooh. Buchanan conducted a comprehensive investigation which revealed ample probable cause to charge the plaintiff, Karen Reed, for causing the death of Officer John O'Keefe by striking him with her vehicle. 81, like just over and over. Again, this is the word that they're sticking with, is ample probable cause. All we need is probable cause. Now, rather than investigate their friends and, Proctor, Buchanan, Tully, all these people, they just targeted Karen. Buchanan stated that he was satisfied that defendant Proctor was not biased or conflicted in conducting this investigation. Buchanan further states that the text referenced in this paragraph speak for themselves. Buchanan denies that he liked Proctor's comments about Miss Reed and states that his response was referring to the search of Miss Reed's phone. Oh boy. Buchanan not only denies, but states that the notion that any MSP trooper manufactured the case against the plaintiff, Karen Reed, is preposterous. Buchanan further states that he and other MSP troopers conducted a comprehensive and thorough investigation, and the suggestion that he and or any other trooper generated any false and incriminating evidence is fiction. Well, somebody did some shit. Buchanan agrees that Miss Reed's Lexus SUV was seized at her parents' home in Dighton. Buchanan further states that when he observed her SUV in Dighton, he noted a broken taillight. Denied that Miss Reed's Lexus taillight had a minor crack and that the taillight was intact before it arrived in the garage. Denied that the crack occurred when Miss Reed backed into Mr. O'Keefe's car at 5 a.m. that morning as she was leaving to search for him. As to the video reference in this paragraph, it speaks for itself. Buchanan further states that he observed that the taillight was broken when he first observed it in Dighton. Admitted that Proctor and Buchanan followed the vehicle from Dighton to CPD and arrived just moments after the tow truck with the Lexus. Denied that the taillight was damaged at some point after the vehicle arrived at the Sallyport, and further states that the taillight was most likely broken when Miss Reed backed into Mr. O'Keefe. The surveillance video and CPD access card swipe log referenced in this paragraph speaks for themselves. Buchanan not only denies, but states that the allegations in this paragraph are wholly fictitious and preposterous. What is 92? Uh-oh, we have a new motion. Karen Reed, they're going nuts. I love that Turtle Boy can't fucking blackmail Karen Reed into giving him any fucking material. And that we don't have to see it on his live broadcast, his leakage, his leaky ass. Okay, so 92, let's see. On one or more of them destroyed the taillight, secretly took pieces of it to their possession, and then planted some of the and on Mr. O'Keefe. This is preposterous. Buchanan denies that he and Proctor ever manipulated the right rear taillight, presented false evidence. Buchanan had no role in deleting any footage from any camera, and further states that the video recordings speak for themselves. Buchanan denies that he did anything to hide the videos. Buchanan denies that he had any role in springing the videos on the defense. That'd be Lally. Buchanan denies that he ever provided any false testimony about the video. Buchanan states that the suggestion that he or any other MSP trooper attempted to mislead the jury or tampered with the taillight is false and wholly manufactured from someone's fertile imagination. Oh, fertile imagination. Dude. Buchanan denies the preposterous allegations contained in this paragraph, which is 95, which is Proctor and Buchanan took taillight pieces from the Sally Port, brought them back to 34 Fairview to plant them in the location where Mr. O'Keefe's body was found, and then falsified various documents in an attempt to hide their conduct. That's just absolutely fucking preposterous. Did not happen. Admitted that Proctor applied for the search warrant to the Stoughton District Court and Norfolk Superior Court for searches of Google electronic records. Ring video, Miss Reed's phone, Miss Reed's vehicle, and cell tower records. Denied that Proctor's assertion that he seized the Lexus at 5:30 p.m. was intentionally false and done to hide any facts, as they were numerous ways to confirm the timeline, and misrepresenting the time would have served no purpose, as the exact timing was and is easily demonstrable. So he's saying that there were numerous ways to confirm the timeline. So denied that Proctor's assertion that he seized Alexis at 5:30 p.m. was intentionally false. But he didn't write that he seized it at 5:30 p.m. Right? Oh, no, he did see it, but he sees it at 4:30. He's saying that it was just a simple what? I fucking don't know what time it was. 97. Buchanan denies the allegations that there were any false narrative by him or any other MSP trooper, and states that the plaintiff's suggestion that MSP troopers planted evidence is wholly without basis of fact. Well, then one would have to ask themselves, why the fuck do y'all think that Karen Reed was found innocent? You know what I mean? That's my question is, if you guys did such a bang up job, why the fuck is Karen Reed free? They better. And they better cut out the getting cute shit. Like, keep it just fucking simple. The theatricals need to fucking stay home. Because I'm over it. I'm over the pirouetting and shit. Okay? Like, this isn't fucking Hollywood. Let's go. But I don't think it's gonna continue. What else? Buchanan denies that either he or Proctor did anything with O'Keefe's clothes designed to taper with the investigation. It was supposed to be tamper. I don't know. I just don't know how you can just like not. There's no chain of custody that just has clothes laying around for fucking days. Buchanan's memory is that he and Proctor went to the Norfolk District Attorney's office with O'Keefe's clothing on January 29th. After transferring it to a secure area, they laid out the wet clothing on butcher paper to dry out. Buchanan remained at the Norfolk District Attorney's office until about 8:30 p.m. Buchanan further states that he always testified truthfully. He always testifies truthfully. Well, 99, it states that y'all... In his trial testimony, Buchanan asserts that both he and Proctor were at the Norfolk District Attorney's office drying out O'Keefe's clothing on butcher paper well into the evening, at least until 8:30 p.m. But in front of MSP trial board in March of 2025, Proctor testified that he arrived back home at 7 p.m. that night. Furthermore, Proctor stated that he went from a debrief at the CPD straight home and never mentioned visiting NDAO with Buchanan and handling key items of evidence, despite Buchanan's claim that Proctor was handling the clothing that night. On these matters, Buchanan and Proctor's sworn statements significantly differ and cannot both be true. So 99 is good. It's what you want to stick to. And Buchanan's memory is that he and Proctor went to Norfolk. So he and Proctor. So he's basically saying Buchanan's memory is that he and Proctor went to, okay? And Proctor's like, the fuck I did. Again, Trooper Proctor is like, I did not do shit with O'Keefe's clothing. So Proctor and Buchanan also failed to create a log, to document the chain of custody of the clothing. Therefore, and by design, there is no record of when, how many times, and under what circumstances Proctor and Buchanan touched, manipulated, handled, or otherwise tampered with the clothing. Buchanan vehemently denies that he tampered with the clothing. (102) Here, in violation of MSP's stated policies, the chain of custody for all of John O'Keefe's clothing, as well as dozens of pieces of taillight, does not begin until March 14th, nearly 2 months after it was collected, when Proctor finally submitted it to the MSP crime lab. At some point before providing those clothes to the crime lab, Proctor and Buchanan placed pieces of SUV taillight on them where they were then identified by the crime lab in 2023. He's saying, that's 102. Buchanan's like, fuck that. Flat out denial. As to the remaining allegations, Buchanan is without knowledge or information sufficient to form a belief as to their truth. However, it should be noted that the plaintiff's narrative contains inconsistencies and defies simple logic. Claiming on the one hand that Buchanan and Proctor had unfettered access to the evidence, while on the other hand alleging that they created a complex and convoluted conspiracy to plant evidence at the scene. The plaintiff's narrative crumbles under the weight of her own storytelling. What? Buchanan denies that Proctor or any of the other members of law enforcement planted any evidence in this investigation, and further state the allegations in this paragraph once again are a work of fiction. Okay. Okay, 105. For example, despite evidence that Brian Albert may have had video surveillance at the house, neither Proctor nor Buchanan nor any other member of MSP issued subpoenas to Ring. He says denied. Additionally, noting once again that the plaintiff could have sought a court order or other process or sent an investigator door to door to secure any existing Ring camera footage or surveillance video footage and chose not to do so. Exactly. What the fuck were they doing in day one? Because she was arrested so quickly. Like, you needed to be on this, like, and you had the opportunity to. I was blown. He admitted that Buchanan interviewed Brian Loughran, a town of Canton snowplow operator, and relayed all relevant information to the Norfolk District Attorney's Office. As for remaining allegations, Buchanan is without knowledge or information sufficient to form a belief to the truthfulness. What the fuck? That is, Proctor and MSP also failed to track down other important witnesses and evidence. For example, Brian Loughran, a town Canton snowplow, turned out to be one of the most significant witnesses in the entire criminal trial. Proctor and his colleagues never spoke to him during their investigation and only did so once Loughran was interviewed by a separate law enforcement agency and provided statements inconsistent with MSP's narrative 18 months after Ms. Reed was already indicted and awaiting trial. (107) Buchanan is without knowledge or information sufficient to form a belief as to the truthfulness of these allegations. Buchanan was unaware of this witness until after the witness had spoken to the plaintiff's defense team. So he's saying that we did not know that Lucky existed until after. So 107 here, it says that specifically Lucky drove his snowplow by the house multiple times in the early morning hours of January 29th, including at 2:30 a.m. and 3:30 a.m. He reported that there was nobody on the lawn at 34 Fairview, nor cars on the street in front of the house at 2:30 a.m. Mr. Loughran believes he would have seen a body had it been on the lawn where Mr. O'Keefe was found several hours later. Instead, the second time he drove by the house around 3:30, he saw a Ford Edge in front of the Alberts home that had not been there an hour before. Had to say fucking Ford Edge. Unfortunate. Anything else worth a damn? Buchanan denies that any member of MSP hid any evidence from anyone. He further denies that there was any improper collaboration between MSP and CPD to hide evidence. The videos referenced in this paragraph speak for themselves. (113) This is fucking crazy. This is crazy. 14. Moreover, because of their close relationship, Proctor, Buchanan, and Tully worked together with CPD in hiding certain videos from Karen Reed's criminal defense team. Specifically, upon information and belief, MSP and CPD collaborated to keep exculpatory surveillance video from Karen Reed's criminal defense team in preparation for the first trial. Those videos captured Higgins' activities in the CPD parking lot and outside the police station shortly after the physical altercation at the house that led to Mr. O'Keefe's death. These videos demonstrated that Higgins' statements about his post-house party activities on the night of O'Keefe's death were not accurate. Upon information and belief, CPD knew it had this evidence and worked with MSP to keep it from Miss Reed. Buchanan admits that the plaintiff was acquitted after the second trial. Buchanan further states that the notion that there was any deception by forces aligned against her was manufactured by her defense team. The fuck is going on? This is crazy. What do you guys think about this shit? Damn. Buchanan is without knowledge. Upon information and belief, Miss Reed is marketing her story and her public appearances for substantial compensation. Oh my God. Woo! You know what? Dude, no knee-jerk reactions here, Karen. Additionally, Much of the public scrutiny she has faced is a result of her and her defense team feeding information to the media. Fucking A. Oh my God. Let me see what 119 is all about. Beginning in January of 2022, the defendant's actions have had a profound effect on Miss Reed. She lost her employment and income. She lost her professorship. She lost blah, 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 a latest arrangement. Blah. So that was what he responded with on 119. Upon information and belief, Miss Reed is marketing her story and her public appearances for substantial compensation. Additionally, much of the public scrutiny she has faced is the result of her and her defense team feeding information to the media. Oh my God. Buchanan states that there was no corrupt prosecution of Miss Reed. Oh shit. Buchanan states there was no plan by anyone to frame her, and the only person responsible for her extraordinary damages is Karen Reed. Oh shit. Oh fucking A, man. It's on like Donkey Kong. Buchanan never fundraised for the House defendants. As a fellow victim of Karen Reed's fan base's personal attacks, he posted a link on his Twitter account that is designed at defending the truth. Oh, for fuck's sake. Karen Reed's fan base. The allegations in this paragraph refer to the other defendants, blah, blah. Additionally, the plaintiff could have called Proctor or anyone else as a witness at any time, so the suggestion that he was hidden from the jury is intentionally misleading. She could have called him. Damn. All right, so then it goes to the... Buchanan never had any discussions with Proctor in relation to his grand jury testimony. Okay. So he's just reasserting things. Okay. Okay, well, wherefore the defendant denies that the plaintiff is entitled to judgment in any amount against the defendant and asks this honorable court to enter judgment for the defendant and against the plaintiff along with interests, costs, and attorney fees. Affirmative defenses. Affirmative defense number 1. By way of affirmative defense, the defendant states that the complaint fails to state a cause of action against the defendant upon which relief can be granted. Affirmative defense number 2. By way of affirmative defense, the defendant states that the defendant is entitled to qualified good faith immunity. Affirmative defense number 3. By way of affirmative defense, the defendant states that his actions are immune from suit as they were discretionary functions. Affirmative defense number 4 states that none of his acts or omissions were approximate cause of injuries or damages, if any, alleged sustained by the plaintiff, nor were these alleged injuries or damages caused by any person or entity within the defendant's responsibility or control. So Leonard H. Heston That's who signed this. The defendant claims a trial by jury as to all issues properly triable to a jury. What in the fuck? Oh boy, who's this? Okay, so wow. Special. Next. This is defendant Lieutenant Brian Tully's motion to dismiss plaintiff's amended complaint and memorandum in support thereof. Holy shit. Okay. Okay. We'll look at Brian Tully's a different day. I want to look at that. What is this about? Matthew Farwell. I'll take a look at this too. All right, that's gonna wrap it up. Holy shit. Okay. Wow, I just don't even have any words for this. This is gonna get nasty. And a judge, they need to rope this, they need to get a handle on this. Holy shit. Oh, for fuck's sake. All right, well, somebody did something right because we all watched it. So, all right, guys, we'll see you on the next one. Join me tonight. I'll be live with the Idaho 4 case. Yep, that's all. This is crazy. These people need to get fucking lives. I would do a rant about Turtle Boy, but I think he knows that he is cooked, as cooked could be. So, is it going to be televised? I don't think so. Turtle Boy's case will be televised. So see you guys in the next one. Thanks so much. Appreciate you.